language is, I'm not going to give an instruction. I can't do that.
And honestly, Judge, it seems like we're making a mountain of a molehill over this issue as well. And I actually am in favor of not giving any stipulation instructions.
Well, I'm not going to comment on the mountain out of a molehill, but it is, because this is a request for an instruction on evidence that wasn't actually presented. Unless there's a stipulation, I don't think I can give an instruction.
Well, part of this, Your Honor, was...
I know what the issue is. It doesn't change the outcome. Either you can call Catherine Strobel.
I could get her down here by 1:30.
Well, you guys need to talk about how you're going to do it, because I can't make you guys reach a stipulation, and I can't tell the jury what evidence is that hasn't been presented. So give this instruction?
Yes, except though just take out the line, Gannon being found for a period, and the defendant said she was never in court, just take that out.
So it would end in
Yes.
being found in Florida.
Yes.
I can do that. Okay, Mr. Allen, do you stipulate?
Yes, Judge.
Okay. Okay. And obviously you guys can still argue that. So, okay. All right, I'll take care of that. Don't go anywhere yet. The other issue is, this may be a Mr. Young issue, as well.
I'm in the room and you know that.
Okay. I looked at the verdict forms and I don't think they're right.
So did you not see the email that I sent yesterday?
No.
Okay, so I sent another copy. I copied you on it, Mr. Sproul, and all the parties.
Okay.
There was a structural error in the forms that we had submitted. What I submitted yesterday is actually straight from Colby.
Okay. This was a error that I found yesterday in all of them.
Is this the version?
No, this is what you originally sent, and then I crossed out this language.
Well, I think Colby actually requires you to list the rest of the charges out. But if you look at the other form that you were talking about with Roman numerals,
right?
We were talking about Roman numeral. It actually says to go to Part A, which is this, and then it tells you to do this. And then my understanding in Colby is that are supposed to list out all the other charges.
Here's the problem I see with that. The way the instruction reads right now is, if you find the defendant not guilty of murder in the first degree, and you also find her not guilty of murder in the first degree, child under 12, position of trust, tampering. So it would be, if you find her guilty of murder in the first degree and you find her not guilty of all these other charges.
Well, this first part is not guilty of basically all the charges, then you answer this question.
Correct. You're right. But my whole thought is, they're not required to find her guilty or not guilty of all of them. They could find her not guilty of murder in the first degree after deliberation and still find her guilty of tampering with a deceased human body. And this question, the special interrogatory down here, only applies to murder in the first degree after deliberation.
Right. So each verdict form would have the exact same.
It does.
Here, but then the question actually applies to the charge for that particular verdict form.
Okay. The concern that I had was, the concern that I have is that suppose that a jury were to come back and find the defendant not guilty by reason of insanity as to murder in the first degree, both counts, but were to find her guilty of tampering with a deceased human body, then they wouldn't answer this question at all. Yeah.
I think that's what we just cross that out
right
on each different verdict form, so that
right.
Part B only reflects to the charge on that verdict form.
Right.
I think it is a little cleaner and less confusing.
Because otherwise, what you have is they only fill that out if they find her not guilty on all charges, and then they find NGRI as to each charge on each verdict. I suppose out of all the realm of possibilities, they could find that she's not guilty on both counts of murder. But if they find her guilty of tampering with the deceased human body and physical evidence, this instruction tells them nothing about that interrogatory.
Yeah, I totally understand what you're saying. That's the same thoughts that we were having as we were drafting these. The concern is obviously that Colgie actually has it exactly like that. And I'm always reluctant to change what's in Colgie just because of issues.
Right. And I get that.
Yeah.
And I guess that's
Mr.
what we're
Tellini?
having it cross out. I think it's cleaner and less confusing to the jury. Okay.
As long as the.
Yeah,
Okay.
I would agree to that. I think it's just cleaner
To cross it out.
to cross it out.
Okay.
I think
I'll take-
sometimes Colby doesn't anticipate that you'd have these types of things where you have multiple
Right.
different charges where they could.
Right. Because
And
it's
not
over a
one.
period of time.
Yes, but yeah, especially because it is.
So, I'll give that to Mr. Young. Can you make those changes? Email them to Mr. Actually, Ms. Gratiano is the one doing the heavy lifting. Can you make those changes? Okay, and send those to Mr. Sproul. And then, so essentially what it will be is when we get there, this part B is just going to say, if you find her not guilty of murder in the first degree, then answer the question. Because the concern that I had was what if we do this, then they're not answering this question at all,
I understand.
which is
exactly.
bad for everybody.
I understand.
So,
It's called because more confusing than it should.
well, I still blame Judge Gilbert because he's on that committee, so,
Well, I think especially because you don't often have, crimes that occur over.
and that's the other issue.
Period, and that's what
Right.
makes it more confusing and actually more of an issue in
Right.
this case with having.
Right. Okay, so I'm gonna give this one with the modification. Are you able to do that, Ms. Gratiano? Told you I wasn't gonna impose time limits. I'm just trying to logistically plan, that's all. Do you have an idea as to how long your closing's gonna last?
It's hard for me to predict how long mine's gonna last. Mine's the rebuttal close.
No, I'm talking about, I'm mostly concerned about the front end.
I'm trying to keep it to an hour.
Okay, how long? Okay. So it may be. Probably what will happen is the closing arguments are going to start 10-ish. Most likely what will occur is that we get through prosecution, defense, take a lunch break, and then come back for rebuttal, would be my guess. I think it's too long to have the jury all sitting together, missing lunch and everything like that, to do it all in one chunk. So, and it's probably going to take me about 40 minutes or so.
Yeah, it'll take.
Um,
It takes at least that long for it.
Yeah. Yeah, well, it'll probably take me about 40 minutes to get through the instructions. So that's kind of what I'm planning on. If it turns out that we're way ahead, and we may be able to finish in the 12:30 hour, be ready for rebuttal
My
if you need
preference
to.
would be that we just get them all done.
It's mine too.
I know, yeah.
I just, it's a long time for them to be there. The other thing is, for everybody who's in the courtroom, there's a couple of rules. Number one, no phones. Number two, no phones. The only people that are going to have their phones out are the people in the first 1.5 rows. Those are press people. We know who they are. If you leave the courtroom during a break, you can't save a seat. So take all of your stuff with you if you leave the courtroom, so that when you, if you don't get back in, you have it with you, because somebody else may come in and sit where your stuff is, or move your stuff or whatever. So keep that in mind. Council approach, please. Right. In addition, generally, if you leave the courtroom during an argument, you're not going to be allowed back in. So the only time that you go out and come back in is during a break. I know that this is a difficult case for everybody. Jury's working hard. Lawyers have worked hard. You got decorum orders back there about the conduct that I expect. If you think that there's going to be an emotional reaction, step outside. We don't want anybody to be influenced by an improper reaction from the gallery. So we'll leave it at that. So she's working on the verdict forms. I'll take care of this instruction. I'm going to number it. I need to see. Oh, I've got them right here. And I'm going to number this an A instruction since we've already got the other ones numbered in that way, as opposed to putting it at the end. Okay.
Okay.
And then you can just shuffle it in on the other ones. Yeah, that'll work. Right. Are they stapled?
No. You
Is
were
it-
at the beginning and the end of the stack.
I was thinking, oh, I guess you would have to, I was actually going to put it up here at like number 10A or something like that, but you'd have to go through all the stacks.
Okay, I mean.
You can do that?
Yeah.
Okay, all right. Okay, all right, so court will be in recess, and when we come back and bring the jury in, rest, yes?
Yes, sir.
No rebuttal?
That's right.
Okay, and then I will tell the jury what they can expect and how it's going to go forward. Once I read the instructions, we'll take that 15-minute break or so, and then we'll go into arguments. We'll see where we are. I mean, if Mr. Young doesn't take as much time or Mr. Tellini doesn't, it may be that we get it done. It's not a hard and fast noon, but I sure don't want to put them in at like 1 or 1:30 and.
Yeah, and as far as if we can get them all done before we break for lunch, there will be a natural break anyway between Mr. Tellini
Right.
and then me doing my rebuttal close. I'm gonna have to rearrange a little bit here anyway.
I'm glad you brought that up. Can we turn that camera on so that they see? We rearranged the camera and you can see, so you can see where you can be seen in the courtroom if you want to do that and take a look at the camera. My suggestion, however, would be if you're going to use this easel, that you unbury it before we start. So it'll be a little, as opposed to trying to move all that stuff afterwards. So, okay. All right. Court will be in recess then. Thank you.
All right.
Good morning. Can you guys hear me all right? Guess what? I forgot to plug in my microphone. So what did we miss? Are they just going to call the jury in at the 9 o'clock normal time? Kind of what it sounded like. Recess. I thought they just started. Right? Uh-huh. Okay, so while they're waiting, these were posted on Twitter. Trying to find out who actually posted it so I can give them credit for it. It was Ashley Portillo, I think. Anyway, so these were the jury questions that we were not able to hear on Wednesday. And can you guys hear me okay? Deanna. Yeah, Renee, the jury questions were good. So I wanted to go over them real quick since we all did miss them. You guys might have already read them. But for those that watch the replay, I'm just going to go through them real quick while we're waiting on court to come back. So the first question was, let's see if I can make this bigger for my eyeballs. Okay, what, if any, significance does the defendant giving enemas for a relationship with Gannon? And the answer from Dr. Lewis was, if true, it's sodomy, repeated, unnecessary, unpleasant, and humiliating. It's a common antecedent to sexual abuse experienced by those who develop dissociative disorders. The thought they begin to have because it's so painful and humiliating. If it indeed it happened to Leticia, it's common for a patient to repeat the behavior as an adult. And I've seen some wild theories about that whole enema situation. None that I want to go into here, but they're out there. They might not be so wild, but not something I want to discuss. So the second question, you said the number of dissociative identity cases increased after you opened the clinic at Bellevue. Did number drop after the clinic was closed? And her answer, it's not been studied, but I'd say yes. If yes, why were they dependent on the existence of the clinic? It's not the diagnosis that is dependent on the phenomenon. It's that the recognition diminishes. It's common for me to get calls from physicians who are familiar with it about how to diagnose and treat. There are not many physicians competent to make a diagnosis. Well, Miss Lewis, you didn't appear too competent either. The third juror question, what is your specific training to determine if a patient is feigning or malingering? In other words, lying, like Leticia. Dr. Lewis said, having read the study, it's my understanding there is no good definition or standard for malingering as opposed to other disturbances and is commonly used in courts. You'll find the diagnosis is made more commonly in forensic cases than in others. But it's not a well-defined phenomenon, and you have to be a little skeptical when someone suspects someone of malingering, especially when there's a penalty involved. The person is more likely to be accused of malingering. It's not a well-defined phenomenon. Well, I think Leticia was malingering with Dr. Lewis. Did you guys see the video where she fist bumped her after, I guess it was Maria that wrote the confession in Latin, and she hands a note over to Dr. Lewis, and Dr. Lewis like fist bumps her? Weird. You did see it, Renee? Like, what? Why would you fist bump? Like, ooh, you just gave me what I needed kind of thing. It was just strange. Another question, did you do any tests to determine if feigning or malingering is present? And all she said was yes. The shortest answer she gave. Next question. You said people with dissociative symptoms are suggestible. Then why describe her behaviors in front of her? Really good question. And Dr. Lewis said, it's an art in part to be able to inquire about symptoms or signs without suggesting them, but try to never go by what someone said. We must have data that annotates whatever we said. That's why we look at things like styles of penmanship, behaviors noted by others. Is it just me? She didn't seem to give very good answers, did she? Like, I feel like they're just not straightforward answers. The next question. If an MRI and EEG are not completed, how did you render your decision? What made it final? Dr. Lewis said, in my mind, the decision is still pending. Interesting. I'd like to consult my neurologic colleagues and get more testing involved because it's an open question. There is a neurologic phenomenon that looks like this. Existence of psychosis is evident, and I think you saw it. I don't know, so I'm not so sure we saw psychosis. We saw her faking psychosis. You're not going to see a better example here that she suffers from a psychotic disorder, and there can be little question. Whether did the explanation to personalities and violent repetitive acts can also be explained by other disorders. However, psychosis, there is no question that this is and was psychotic. Yeah, the jurors are pretty smart. They asked really, really good questions of this doctor. And then the final question was, did you have additional evidence that was corroborated through time? Dr. Lewis said, because I was not permitted or able to interview these people myself, I have you questioned some responses I got. There were people who reported to others the changes that seemed reasonable, but if I haven't seen it myself, and it hasn't been well documented in this case, I had to rely on what other people said. What was very interesting was the finding that she called herself Maria at an early age, and that behavior was a core aspect of how she behaved. There was no evidence that she called herself Maria at an early age. None. And she didn't interview any family or any friends. So who was she relying? The other people. So the other people could have only been the courts, the nurses, the other psychologists, things like that. Because she said yesterday or Wednesday, she was not able to speak to any family or friends. You very well could be right, Renee. I wouldn't be surprised whatsoever if she continues to try to talk with her and interview her while she's in jail or wherever she winds up. I think jurors should be allowed to ask questions on every trial. So in Colorado, they are. That's just part of the Colorado judicial system. But I agree. It'd be great if every state adopted that. I don't know how long they're going to be, if they're going to come in at 9 o'clock their time or not, but we can go through this. There was so much that we missed the other day. The video feed from the courthouse kept going down. The audio kept cutting in and out. The interview between Dr. Lewis and Leticia, it was really hard to hear a lot of what Dr. Lewis was saying in it. And Renee was in the courtroom on Monday, and she did say that the jury and the people in the courtroom can hear all those things very clearly. It's just the feed that we get, the audio and video feed from the courthouse, has not been great all the time. So Ashley is one of the, she's from KOAA, and I believe that is local Colorado Springs. So I'm just going to run through real quick what her recap of Wednesday was, because we really did miss out on a lot of things. So if you guys don't mind, if you want to hear it, we'll run through it real quick until they come back in and start court for the day. All right. So she said the defense continued to make its case Wednesday as the murder trial of Letecia Stauch continued. The defense began Wednesday by filing a motion to drop all charges against Letecia Stauch, specifically focusing on the first-degree murder charges she's facing. And that's pretty normal for the defense to file those motions at the ending of it. Josh Tolini, Leticia's lawyer, claimed there is a lack of evidence from the prosecution proving that the murder of Gannon was premeditated by Stauch. District Attorney Michael Allen said there's been more than enough evidence of premeditation, including the searches found on Stauch's phone before Gannon's disappearance, like searching for a one-bedroom, one-bath apartment in Florida and employment opportunities elsewhere. Cross-examination continued for Dr. Dorothy Lewis, a psychiatrist who conducted a sanity evaluation on Leticia Stauch. Yesterday, which would have been Tuesday, cross-examination from prosecutor Dave Young got heated as he pressed Dr. Lewis about her credibility and evaluation of Stauch. Young asked about dissociative identity disorder and the controversy around it. The essential controversy is whether people believe it exists or not, said Dr. Lewis. Dissociative identity disorder is a widely debated topic within the American psychological community. Many of them don't believe that it exists. Young asked Dr. Lewis how she knows if someone is acting out their symptoms. What I do is be able to show that there were unmistakable signs of switches, changes, different states, and different abilities to function, long before I was ever asked to be in any case, said Dr. Lewis. Dr. Lewis said she remembered in her notes about Stauch, someone had said when she was younger she asked to be called Maria. That in and of itself is not proof of anything, but it's a confirmation if you have a lot of other things that go along with it. Well, when she said she remembers in her notes about someone saying that was most likely Leticia self-reporting as usual, saying that, hey, when I was younger, I asked, to be called Maria, but there's no proof of that. As Dr. Lewis is describing her notes about one of Stauch's relatives saying she called herself Maria Sanchez, District Attorney Michael Allen was shaking his head no. Young told Dr. Lewis, your obligation as an expert is to turn over all information. Why was that not in your report? This is an observation as you go through hundreds of pages of notes, so I'll jot it down and think, gee, that's kind of interesting, replied Dr. Lewis. Young asked Dr. Lewis if she considered that all of Stauch's family members said they didn't notice Stauch showing signs of dissociative identity disorder. I didn't think about that specifically. It's interesting that they did not notice this, said Dr. Lewis. You think it's interesting that none of her family said that they had ever noticed any kind of signs. Do you think anyone who commits murder has a brain injury? Asked Young. No, replied Dr. Lewis. Young moved on to talking about Stauch's actions when calling Gannon school, saying he would not be there. Dr. Lewis, it's a puzzle why she called in saying that he could not go to school. Young, so it had nothing to do with planning? Dr. Lewis, I don't know. It could have had to do with planning. She didn't know a lot. Young asked about the fact that she used 3 separate instruments to kill Gannon, asking, does that tell you she has the capacity to inform the intent to kill? Dr. Lewis responded, I don't know. I can't be certain what was going on in her head. I don't know why she had a gun in her hand or why she shot Gannon. It is not clear that she simply wanted to kill. This is a child she loved. If we want to believe what other people said, she loved Gannon, said Dr. Lewis. Young continued on to ask Dr. Lewis if she believes Stauch knew right from wrong when she put Gannon's body in the back of her car while driving it to the airport. I don't feel qualified to conclude that. She certainly had the capacity to move it from one place to another. Whether or not she felt this was right or wrong, I can't speculate, said Dr. Lewis. Any speculation is possible. If the body is in your car, you may want to avoid going anywhere near that car. She had the capacity to know that she needed to hide the body. I can't move on to say, yes, she knew right from wrong, said Dr. Lewis. I find crazy what you find logical. It's crazy when you say Eduardo comes and rapes her and takes off with Gannon. The whole concept is crazy. The whole story of Eduardo is crazy. Well, now she's thinking like the rest of us. Pieces of video from the sanity evaluation conducted in November between Dr. Lewis and Leticia were played for the courtroom. Going into this interview, did you have any concerns that Mrs. Stauch may not be truthful with you? Young asked Dr. Lewis, to which she replied, of course. In the interview, Stauch said that she calls her lawyer, Josh Leaney, by his first name, Josh. But she said her alter ego of Maria calls him asshole in Spanish. Maria calls everybody asshole. In the interview, Stauch is describing her ego named Jasmine, saying she has a lot of risky behaviors, gets in trouble, drinks a lot, and parties a lot. I'm not a partier, said Stauch. So see, that's one of the things I don't think we were able to hear that because I don't remember hearing it. I can be at work and be okay, and then something really stressful happened, and then I'll end up on a plane somewhere. My body goes through the motions. Well, she wasn't really a frequent flyer, but whatever. Dr. Lewis testified about when Stauch said she had talked to a friend in Russian, and at one point, Stauch began speaking to Dr. Lewis in what sounds like Russian. It ain't Russian. It's some kind of entity that sounds like Russian, said Dr. Lewis. I am all over the place. It was not my intention to hurt Gannon. No, absolutely not. I loved Gannon. It would not be to hurt a child. Absolutely not, said Stauch in her interview. I am being projected as some monster, and you don't know that this is not me. I don't do these things. I thought this was one big nightmare. Sometimes I don't know what's going on and what's not really going on. But when bad things happen to good people, it's hard, especially because I'm sitting there lost, said Stauch. During the interview, Stauch said she was planning on leaving her husband. She said Gannon told her to leave, and Stauch said she should have just listened and gone back to the East Coast, and then everyone would have been safe. Hey, crispy treat. Right, Renee, whatever, teabag. Stauch said Gannon said he can go with her. He knew I was leaving to go back home to the East Coast. I said, son, I can't do that. It's kidnapping. If I would have just did that, everyone would have just been fine, said Stauch. Weird thing to say. Jurors were shown a clip of an interaction between Lewis and Stauch, which appeared to show one of Stauch's alternate personalities. I'm not a violent person. I'm not violent at all. I don't do this to people. If someone is trying to hurt people, I'm going to make sure they're okay, because that's what I do each and every time, said Stauch. Who am I talking to? Asked Dr. Lewis. Taylor, Stauch replied, as she began apologizing because she said she doesn't remember what the two were just talking about a minute ago. Excuse me. Dr. Lewis said during her testimony of the clip, this is a technique, the way in which we learned about. How do you get to talk to alternate senses of self? We asked them, how would we get to talk to this person? By and large, they have a special place that they go. It is known. How do you know she's not fooling you? Asked Young. Watch, listen, see what she's consistent with, replied Dr. Lewis. But Leticia's not very consistent with much of anything. Before court resumed after afternoon recess, and again, we're going back over what happened Wednesday because so much of it was inaudible to the courtroom feed. So Young went on the record saying he does not want Dr. Lewis to testify or talk about documents, including signatures of Leticia Stauch and a confession in Latin. The counsel agreed that those would not be testified about because Dr. Lewis, quote unquote, lost them. During testimony, Dr. Lewis began talking about documents and said she has them in her lap. Young is showing frustration because this is exactly what I predicted. This was going to happen. Remember, they got a little bit irritable there. The judge then asked Young and Tellini to look over the documents during a 15-minute recess. The judge returned and reminded people in the gallery that there is a child who lost his life and a woman who may be facing a life sentence. The judge said no one who is testifying is an actor, and everyone who's testifying has a connection to the case. Wonder why he said that. No one who's testifying is an actor. I've not seen her cry. Have you, Deanna? Young returned to the courtroom and asked Dr. Lewis if she knew the importance of turning over notes during a homicide investigation. Whatever she signed there, whatever I had was turned over to Mr. Tellini to be copied and shared with you, said Dr. Lewis. Young asked Dr. Lewis why she sent an email to Tellini saying, I have been reading more on Leticia, and I think we should drop the EEG request. Young asked why she told the jury yesterday that she never requested to withdraw the EEG. I'm saying there's other things that need to be addressed. I did not consider this withdrawing it permanently. I did not wish to fight with the court of, are you getting this or are you not? Replied Dr. Lewis. More video on the sanity evaluation was played, and Stauch went on to discuss her different personalities, and she said during that moment, she is Taylor. How honest are you with me? Asked Dr. Lewis. I am honest with you, replied Stauch. On January 27, 2020, I had reported Gannon missing because I was calm first, but I didn't think anything was wrong. I thought he was just playing a hiding challenge and he would be okay. I thought he would eventually come out of his hiding spot, said Stauch. I need to talk to Maria, probed Dr. Lewis. Prior to this, Leticia wrote down on a piece of paper, Maria said she will come on her terms, but don't think she answers to anyone. Leticia can only talk to her, not me, meaning Taylor. He was missing, and then I called 911. I started to panic after a couple of minutes. That's when I started to get worried because I realized that it started to rain and get cold outside. They're still not back in the courtroom. Stauch, as Taylor, said Gannon wasn't supposed to die, as she's shaking her head. I did try to bring him back. I started praying over him and trying to bring him back to life. He didn't come back to life, said Stauch. Where was he lying? Asked Dr. Lewis. In my arms, replied Stauch. I am not a monster. I'm not a monster. People thinking I'm just a mass murderer and I just killed someone. Under no circumstances did I know it was Gannon. I never knew it was him, said Stauch. Renee, she said the hiding challenge was like something that the kids had watched on TikTok, something like that. In the video, Stauch then begins talking in what sounds like a Russian accent, saying there was someone in the home who was trying to hurt them. You don't understand. I had to protect the people that were in the house. I had to protect them, and that's all I did, said Stauch. I think court's coming back in. I'm trying to kill.
All right, court will call
That's what I do.
20 CR
That's what I do
1358
for a
people versus
living.
Leticia Stauch. Record should reflect the jury's not present in the courtroom.
I
Is there
took the
anything
gun
we
and
need to pick up
fired the
outside
gun at
presence of the
someone who
jury
had a
at this
cape
point
on.
in time?
A dangerous
Prosecution?
man, said Stauch.
Defense? Let's go ahead and bring the jury in.
We almost got through it, but that gives us a nice rundown on what did happen the other day.
So we'll just take them over there. And I tell them and they can just pass them down. Cameras. Oh. All rise for the jury, please.
I'd never seen it either, Renee. I think she described at some point, like telling the kids, like specific places that they are not allowed to hide and things like that.
Thank you. You may all be seated. Court will recall 20 CR 1358, People versus Leticia Stauch. Record should reflect the jury has returned to the courtroom. Good morning, ladies and gentlemen. We're going to start today like we have every other day. Has anything occurred since we were last together that causes any of you to believe you could not continue to serve as a fair and impartial juror in this case? If so, please raise your hand. No response. All right, when we took our break on Wednesday, we were in the midst of the defendant's case. So that's where we will resume. Mr. Tellini, call your next witness, please. Ladies and gentlemen, what that means is the defense has presented all of the evidence which it intends to present for you to consider the issues in this case. I want to remind you that the defense does not have any burden of proof at any point in these proceedings. However, because the defense did present evidence, the prosecution also has an opportunity to present rebuttal evidence if it chooses to do so, to rebut any of the evidence that was presented by the defense. With that, prosecution, do you have any rebuttal evidence? Ladies and gentlemen, what that means is that all of the evidence which you may properly consider to decide the issues in this case has been presented. Here's what we're going to do going forward. Mr. Combs has some instructions for you. He's going to hand those out. So if all of you would take one and pass it down. All right, the law in the state of Colorado requires that I read these instructions to you, even though you have them with you to take back into court. In addition, because you each have your own individual copy, you can write on your copy any notes that you want to have, just like you would any other notes. Those are not discoverable. Once the case is done, again, those are destroyed. The original jury instructions that I'll give you at the end, those are the ones that need to be filled out. In addition, you'll also see that your instructions start with 9A. That's because we had an addition. So if you hold on to 9A, it's going to go right after instruction 9. Just hold on to it. We'll get there, I promise you. Okay. What we'll do is I will read these instructions, then we'll take about a 15-minute recess or so. Then we're going to come back. Then the prosecution has an opportunity to give you a closing argument. After that, the defense has an opportunity to give a closing argument. After that, then the prosecution has an opportunity to give rebuttal. It's much like rebuttal evidence. They get to comment on anything that the defense had to comment on in their closing argument. So that's the process. I want to tell you, we work almost always on a closing argument, from my perspective, a little bit on the fly, because I've not placed time limitations on the attorneys. However, I'm not going to have you guys sitting there for a 4-hour block of time either. So it may be that we do the prosecution closing, the defense closing, and take a break, a lunch break, and then do rebuttal. The other thing is that since we are here for closing, that means that this case has been concluded. That means that you will be here all day. Normally, you have gone out to lunch, those sorts of things. That won't be happening today. We're going to order lunch in for you. When we take our break, we're going to have somebody come down and they'll tell you about the lunch process and stuff like that. But we're going to have you here today. And once we discharge you, or once we send you back for deliberations, you'll need to stay together for the deliberation period. Members of the jury, the evidence in this case has been completed. In a moment, I will read to you jury instructions that contain the rules of law you must apply to reach your verdict. You will have copies of what I read to take with you to the jury room. But first, I want to mention a few things to keep in mind when you are discussing this case in the jury room. Until you have returned a verdict, you must not do any research about this case or this kind of case using any source, including dictionaries, reference materials, the internet, or other electronic means. You must not communicate in any way with anyone else about this case or this kind of case until you have returned a verdict in court. This includes your family and friends. If you have a cell phone or other electronic device, you must keep it turned off during the jury deliberations. Actually, what happens is we collect all of those. You get them back at the end, and sometimes you even get back your own. But we collect them all at the end. We collect them all and we hold on to them during deliberations. It is my job to decide what rules of law apply to the case. While the attorneys may comment on some of these rules, you must follow the instructions I give you. Even if you disagree with or do not understand the reasons for some of the rules of law, you must follow them. No single instruction describes all the law which must be applied. The instructions must be considered together as a whole. During this trial, you received all of the evidence that you may properly consider in deciding the issues in the case. Your decision must be made by applying the rules of law that I give you to the evidence presented at trial. Remember, you must not be influenced by sympathy, bias, or prejudice in reaching your decision. You should not allow bias or any kind of prejudice based upon gender to influence your decision. If you decide that the prosecution has proved beyond a reasonable doubt that the defendant is guilty, it will be my job to decide what the punishment will be. In making your decision, you must not consider punishment at all. At times during the trial, attorneys made objections. Do not draw any conclusions from the objections or from my rulings on the objections. These only related to legal questions I had to decide and should not influence your thinking. If I told you not to consider a particular statement that was made during the trial, you must not consider it in your deliberations. Finally, you should consider all the evidence in light of your experience in life. The defendant is charged with committing the crimes of murder in the first degree after deliberation, murder in the first degree, child under 12, position of trust, tampering with the deceased human body, and tampering with physical evidence in El Paso County, Colorado, on or about January 27, 2020. The defendant has pled not guilty by reason of insanity. The charges against the defendant are not evidence. The charges against the defendant are just accusations. The fact that the defendant has been accused is not evidence that the defendant committed any crime. Every person charged with a crime is presumed innocent. This presumption of innocence remains with the defendant throughout the trial and should be given effect by you unless, after considering all the evidence, you are then convinced that the defendant is guilty beyond a reasonable doubt. The burden of proof is upon the prosecution to prove to the satisfaction of the jury beyond a reasonable doubt the existence of all of the elements necessary to constitute the crime charged. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence or lack of evidence in the case. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. If you find from the evidence that each and every element of a crime has been proven beyond a reasonable doubt, you should find the defendant guilty of that crime. If you find from the evidence that the prosecution has failed to prove any one or more of the elements of a crime beyond a reasonable doubt, you should find the defendant not guilty of that crime. The number of witnesses testifying for or against a certain fact does not, by itself, prove or disprove that fact. You are the sole judges of the credibility of each witness and the weight to be given the witness's testimony. You should carefully consider all of the testimony given and the circumstances under which each witness has testified. For each witness, consider that person's knowledge, motive, state of mind, demeanor, and manner while testifying. Consider the witness's ability to observe, the strength of that person's memory, and how that person obtained his or her knowledge. Consider any relationship the witness may have to either side of the case and how each witness might be affected by the verdict. Consider how the testimony of the witness is supported or contradicted by other evidence in the case. You should consider all facts and circumstances shown by the evidence when you evaluate each witness's testimony. You may believe all of the testimony of a witness, part of it, or none of it. A witness qualified as an expert by education, training, or experience may state opinions. You are not bound by the testimony of witnesses who testified as experts, The credibility of an expert's testimony is to be considered as that of any other witness. You may believe all of an expert witness's testimony, part of it, or none of it. The way you give the testimony is entirely your decision. Every defendant has a constitutional right not to testify. The decision not to testify cannot be used as an inference of guilt and cannot prejudice the defendant. It is not evidence, does not prove anything, and must not be considered for any purpose. The court has taken judicial notice of a certain fact. You may or may not accept that fact as true. It is entirely your decision to determine what weight, if any, shall be given to the evidence. And this is where the 9A goes. In response to the COVID-19 pandemic, the El Paso County Jail was accepting WebEx meetings on March 20 of. The defendant's attorney had a WebEx meeting with the defendant on that date around noon. Later that day, Dr. Moore had a conversation with the defendant about Gannon being found in Florida. A fact may be proven by either direct or circumstantial evidence. Under the law, both are acceptable ways to prove something. Neither is necessarily more reliable than the other. Direct evidence is based on first-hand observation of the fact in question. For example, a witness's testimony that she looked out a window and saw snow falling might be offered as direct evidence that it had snowed. Circumstantial evidence is indirect. It is based on observations of related facts that may lead you to reach a conclusion about the fact in question. For example, a witness's testimony that she looked out a window and saw snow covering the ground might be offered as circumstantial evidence that it had snowed. Members of the jury, you may discuss this case only when you are all present, and you may only deliberate in the jury room. No juror should attempt to discuss this case with other jurors or anyone else at any other time except when all jurors are in the jury room. Once you begin your deliberations, if you have a question, your foreperson should write it on a piece of paper, sign it, and give it to the bailiff, who will bring it to me. The court will then determine the appropriate way to answer the question. However, there may be some questions that, under the law, the court is not permitted to answer. Please do not speculate about what the answer to your question might have been or why the court is not able to answer a particular question. Finally, please be sure to keep the original question and response. Do not destroy them, as they are part of the official record in this case and must be returned to me when you return the instructions and verdict forms at the end of the case. One other caveat to this instruction is that takes time, because I have to reconvene the court, have to bring the lawyers in, we have to discuss the question, what the possible response is. So it's not as quick as the questions that we have when you're asking witnesses. During this trial, you were permitted to submit written questions to witnesses. If a particular question was not asked, do not guess why the question was not asked or what the answer might have been. My decision not to ask a question submitted by a juror is not a reflection on the person asking it, and you should not attach any significance to the failure to ask a question. By making legal rulings on the admissibility of questions, I did not intend to suggest or express any opinion about the question. My decision whether or not to allow a question is based on the applicable rules of evidence and other rules of law, and not on the facts of this particular case. It is my responsibility to assure that all parties receive a fair trial according to the law and rules of evidence. The fact that certain questions were not asked must not affect your consideration of the evidence in any way. Do not give greater weight to questions or answers to questions that are submitted by yourself or your fellow jurors. In making your decision, you must consider all of the evidence that has been presented. In this case, a separate offense is charged against the defendant in each count of the information. Each count charges a separate and distinct offense, and the evidence in the law applicable to each count should be considered separately, uninfluenced by your decision as to any other count. The fact that you may find the defendant guilty or not guilty of one of the offenses charged should not control your verdict as to any other offense charged against the defendant. The defendant may be found guilty or not guilty of any one or all of the offenses charged. A crime is committed when the defendant has committed a voluntary act prohibited by law together with a culpable state of mind. A voluntary act means an act performed consciously as a result of effort or determination. Proof of the voluntary act alone is insufficient to prove that the defendant has the required state of mind. State of mind is as much an element of the crime as the act itself and must be proven beyond a reasonable doubt, either by direct or circumstantial evidence. In this case, the applicable states of mind are explained below. The term after deliberation means not only intentionally, but also that the decision to commit the act has been made after the exercise of reflection and judgment concerning the act. An act committed after deliberation is never one which has been committed in a hasty or impulsive manner. A person acts intentionally or with intent when her conscious objective is to cause the specific result prescribed by the statute defining the offense. It is immaterial whether or not the result actually occurred. A person acts knowingly or willfully with respect to conduct or to a circumstance described by a statute defining an offense when she is aware that her conduct is of such nature or that such a circumstance exists. A person acts knowingly or willfully with respect to a result of her conduct when she is aware that her conduct is practically certain to cause the result. These next instructions have to deal with the elements that must be proven for the charges, and it makes more sense once you actually have all of the instructions because it references in instruction 21. The elements of the crime of murder in the first degree after deliberation are that the defendant in the state of Colorado, at or about the date and place charged, after deliberation and with intent to cause the death of a person other than herself, caused the death of that person or of another person, and that the defendant's conduct was not legally authorized by the affirmative defense in instruction 21. After considering all of the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of murder in the first degree after deliberation. After considering all of the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty of murder in the first degree after deliberation. The elements of the crime of murder in the first degree, child under 12, position of trust, are that the defendant in the state of Colorado, at or about the date and place charged, knowingly caused the death of a child who had not yet attained 12 years of age, and the defendant was in a position of trust with respect to the child, and that the defendant's conduct was not legally authorized by the affirmative defense in instruction 21. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of murder in the first degree, child under 12, position of trust. After considering all of the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty of murder in the first degree, child under 12, position of trust. The elements of the crime of tampering with a deceased human body are that the defendant in the state of Colorado, at or about the date and place charged, believed that an official proceeding was pending, in progress, or about to be instituted, and, acting without legal right or authority, willfully destroyed, mutilated, concealed, removed, or altered a human body, part of a human body, or human remains, with intent to impair its or their appearance or availability in the official proceedings, and that the defendant's conduct was not legally authorized by the affirmative defense in instruction 21. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of tampering with a deceased human body. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty of tampering with a deceased human body. The elements of the crime of tampering with physical evidence are that the defendant in the state of Colorado, at or about the date and place charged, believed that an official proceeding was pending, in progress, or about to be instituted, and acting without legal right or authority, destroyed, mutilated, concealed, removed, or altered physical evidence with intent to impair its verity or availability in the pending or prospective official proceeding, and that the defendant's conduct was not legally authorized by the affirmative defense in Instruction 21. After considering all of the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of tampering with physical evidence. After considering all of the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty of tampering with physical evidence. In this case, certain words or phrases have a particular meaning. The following are the definitions of those words and phrases. Accordingly, you are to use the following definitions where those words and phrases appear in the instructions and define crimes, defenses, special rules, and verdict questions. Cause means that act or failure to act which in natural and probable sequence produced the claimed injury. It is a cause without which the claimed injury would not have been incurred. Homicide means the killing of a person by another. Official proceeding means a proceeding heard before any legislative, judicial, administrative, or other governmental agency, or official authorized to hear evidence under oath, including any magistrate, hearing examiner, commissioner, notary, or other person taking testimony or deposition in any such proceedings. Person, when referring to the victim of a homicide, means a human being who had been born and was alive at the time of the homicidal act. Physical evidence includes any article, object, document, record, or other thing of physical substance. Physical evidence does not include a human body, part of a human body, or human remains. One in a position of trust includes, but is not limited to, any person who is a parent or acting in the place of a parent and charged with any of a parent's rights, duties, or responsibilities concerning a child, including a guardian or someone otherwise responsible for the general supervision of a child's welfare, or a person who is charged with any duty or responsibility for the health, education, welfare, or supervision of a child, including foster care, child care, family care, or institutional care, either independently or through another, no matter how brief, at the time of the unlawful act. The evidence in this case has raised the defense of insanity as a defense to the crimes of murder in the first degree after deliberation, murder in the first degree, child under 12, position of trust, tampering with the deceased human body, and tampering with physical evidence. The defendant was insane at the time of the commission of the acts if she was so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act, or she suffered from a condition of mind caused by mental disease or defect that prevented her from forming a culpable mental state that is an essential element of a crime charged. But care should be taken not to confuse mental disease or defect with moral obliquity, mental depravity, or passion growing out of anger, revenge, hatred, or other motives and kindred evil conditions, because when an act is induced by any of these causes, the person is accountable to the law. In addition, diseased or defective in mind does not refer to an abnormality manifested only by repeated criminal or otherwise antisocial conduct. Only those the prosecution must disprove beyond a reasonable doubt both of the above numbered conditions. After considering all, you decide that the prosecution has failed to meet this burden of proof, then the prosecution has failed to prove that the defendant was sane at the time of the commission of the acts, which is an essential element of murder in the first degree after deliberation, murder in the first degree, child under 12, position of trust, tampering with a deceased human body, and tampering with physical evidence. In that event, you must find the defendant not guilty and have the foreperson sign the designated section of Part A of the verdict form to indicate your verdicts. After considering all of the evidence, if you decide the prosecution has met this burden of proof, then the prosecution has proved the defendant was not insane at the time of the commission of the acts. In that event, your verdicts concerning the charges of murder in the first degree after deliberation, murder in the first degree, child under 12, position of trust, tampering with a deceased human body, and tampering with physical evidence must depend upon your determination whether the prosecution has met its burden of proof with respect to the remaining elements of this offense. Instruction 22. Concerning the affirmative defense of insanity, certain words or phrases have a particular meaning. Diseased or defective mind does not refer to an abnormality manifested only by repeated criminal or otherwise antisocial conduct. Mental disease or defect means only those severely abnormal mental conditions which grossly and demonstrably impair a person's perception or understanding of reality, and which are not attributable to the voluntary ingestion of alcohol or any other psychopathic substance, except that it does not include an abnormality manifested only by repeated criminal or otherwise antisocial conduct. Moral obliquity refers to an act committed by a person who is capable of distinguishing moral right from moral wrong, but nevertheless acts out a perverse and culpable rejection of prevailing moral standards. Moral obliquity does not include an act committed by a person in a state of mental illness that renders the person incapable of distinguishing right from wrong with respect to the act. Incapable of distinguishing right from wrong refers to cognitive inability due to a mental disease or defect to distinguish right from wrong as measured by a societal standard or morality, even though the person may be aware that the conduct in question is criminal. The phrase incapable of distinguishing right from wrong does not refer to a purely personal and subjective standard of morality. If you find that the defendant, and this question will make more sense once you see the verdict forms. If you find the defendant guilty of one or more of the following charges of murder in the first degree after deliberation, murder in the first degree, child under 12, position of trust, tampering with a deceased human body, and tampering with physical evidence, you should disregard the remainder of this instruction and sign Section A of the verdict form for that charge to indicate your verdict of guilty. If, however, I think that's a typo. I think that's supposed to be B. We'll get to it in just a moment. If, however, you find the defendant not guilty of one or more of the following charges of murder in the first degree, murder in the first degree after deliberation, murder in the first degree, child under 12, position of trust, tampering with a deceased human body, and tampering with physical evidence, you should sign Section A of the verdict form to indicate your verdict of not guilty, and you should also answer the following verdict question in Section B of the verdict form. Did you find the defendant not guilty solely based on the defense of insanity? Answer yes or no. The court reminds you that the prosecution has the burden to prove beyond a reasonable doubt each element of the crime charged, including that the defendant was not insane at the time of the commission of the act. If you decide that the only element of the crime charge that the prosecution failed to prove beyond a reasonable doubt is that the defendant was sane at the time of the commission of the act, you should mark yes in the appropriate place in Section B of the verdict form and have the foreperson sign the designated form in that section of the verdict form. If you decide that the prosecution has failed to prove any other element beyond a reasonable doubt, you should mark no in the appropriate place in Section B of the verdict form and have the foreperson sign the designated line in that section of the verdict form. In any trial or hearing in which the mental condition or of the defendant is at issue, witnesses not specially trained in psychiatry or psychology may testify as to their observation of the defendant's actions and conduct, and as to conversations which they have had with her bearing upon her mental condition, and they shall be permitted to give their opinions or conclusions concerning the mental condition of the defendant. This is an information instruction and must have no persuasive bearing on the verdicts you arrive at under the evidence. If a defendant is found not guilty by reason of insanity, it is the court's duty to commit the defendant to the Department of Human Services until such time as the court determines that the defendant no longer requires hospitalization because she no longer suffers from a mental disease or defect which is likely to cause her to be dangerous to herself, to others, or to the community in the reasonably foreseeable future. If a defendant is found not guilty by reason of insanity, she will never again be tried on the merits of the criminal charges filed against her. The question of the defendant's sanity or insanity has reference to her mental condition at the time of the alleged acts, the condition of the defendant's mind previous to the act charged, and since that time, may be considered only to aid you in determining her sanity or insanity at the time of the acts charged. In a few moments, the bailiff will escort you to the jury room, where you will select one of your members to be the foreperson. Your foreperson will preside over your deliberations and shall sign any verdict form and verdict question form that you may agree on, according to the rules that I am about to explain. The verdict for each charge must represent the considered judgment of each juror, and it must be unanimous. In other words, all of you must agree to all parts of it. This requirement applies to any determinations that you make in response to verdict questions which you conclude should be answered. Only one verdict shall be returned signed for each count. The verdict forms, verdict question forms, and these instructions shall remain in the possession of your foreperson until I ask for them in open court. Upon reaching a verdict, and if required by your verdicts, answering any verdict questions, you will inform the bailiff, who in turn will notify me, and you will remain in the jury room until I call you into the courtroom. You will be provided with 4 verdict forms. You will also be provided with 4 verdict question forms with directions that explain under what circumstances you should complete those forms. When you have unanimously agreed upon your verdicts, you will select the option on each form which reflects your verdict, and the foreperson will sign the verdict form as I have stated. Similarly, if you conclude the verdict question should be answered, you will select the option on each verdict question form which reflects your unanimous decision, and the foreperson will sign each verdict question form as I have stated. I will now read to you the verdict and the verdict question forms. You must not draw any inferences based on the order in which I read them. The verdict and verdict question forms you will receive read as follows. Jury verdict count number 1, charge of murder in the first degree after deliberation. Part A, section Roman numeral 1. We, the jury, find the defendant, Letecia Stauch, not guilty of count number 1, murder in the first degree after deliberation. Part A, section Roman numeral 2. We, the jury, find the defendant, Letecia Stauch, guilty of count number 1, murder in the first degree after deliberation. If you fill out Part A, Roman numeral 1, you are finding the defendant not guilty, and you are finding the issues in favor of the defendant. If you do that, you need to fill out Part B, which asks you the question, if you find the defendant not guilty of murder in the first degree, you should answer the following question. However, if you find the defendant guilty of murder in the first degree, you should leave this section blank. As to the charge of murder in the first degree after deliberation, did you find the defendant not guilty solely based on the defense of insanity? So with respect to each verdict form, you have 3 options. It can be guilty, it can be not guilty by reason of insanity. So if you were to find the defendant just straight not guilty, the prosecution had not presented enough evidence to establish beyond a reasonable doubt that charge against the defendant, you would fill it not guilty and be done. If you were to find the defendant or that the prosecution had presented sufficient evidence to prove beyond a reasonable doubt that she was guilty, you could fill it out as guilty. If you find her to be not guilty because she was insane at the time, you need to answer not guilty and answer this question on the back. Verdict form number 2, charge of murder in the first degree, child under 12, position of trust. Section Roman numeral 1, we the jury find the defendant Letecia Stauch not guilty of count number 2, murder in the first degree, child under 12, position Roman numeral 2. We the jury find the defendant Letecia Stauch guilty of count number 2, murder in the first degree, child under 12, position of trust. Again, only if you find her not guilty should you consider the question on part B. As to the charge of murder in the first degree, child under 12, position of trust, did you find the defendant not guilty solely based on the defense of insanity? Verdict form or count number 3. We the jury, part A, Roman numeral 1, we the jury find the defendant Letecia Stauch not guilty of count number 3, tampering with a deceased human body. Roman numeral 2, we the jury find the defendant Letecia Stauch guilty of count number 3, tampering with a deceased human body. And the same question on the back under part B. Jury verdict form count number 4, charge of tampering with physical evidence. We the jury find the defendant Letecia Stauch not guilty of count number 4, tampering with physical evidence, or Roman numeral 2. We the jury find the defendant Letecia Stauch guilty of count number 4, tampering with physical evidence, and the same question on part B. So let me go back for a moment. Double check this. Section A. All right, let me call your attention back because I may have introduced some confusion. If you look back at instruction 23, and I said I thought this might be a typographical error, it is not. That is an accurate statement. If you find the defendant guilty of one or more of the following charges of murder in the first degree after deliberation, murder in the first degree, child under 12, position of trust, tampering with a deceased human body, and tampering with physical evidence, you should disregard the remainder of this instruction and sign section A of the verdict form that for that charge to indicate your verdict of guilty. That's an accurate statement. What I was thinking about is that it also implicated the insanity provision. But under section A of each verdict form, you're determining whether she's not guilty or whether she's guilty. So instruction 23 is accurate the way that it was stated and the way that it was read to you. I just didn't want to be any confusion about that, since I may have introduced some. So what we're going to do is take about a 15-minute recess. So if I can have everyone back in the jury room at, say, 5 after 10, we should be able to start on time. Again, even though you've gotten the instructions, still can't start deliberating yet. You have to wait. So don't talk to each other about it. Don't talk to anyone else about it. Don't do your own independent research about any aspect of the case. We'll see you at 10 after 5 when we come back. My hope is that we will probably go until noon. We might go a little bit longer. So, because it would be better to have all of the arguments together. But again, as I said, I don't want you guys to be sitting there for a really long time either. So I'm just going to have to work that out on the fly. So with that, I'll rise for the jury, please.
Mercy. So another recess. Yeah, Al is there.
I think you may all be seated.
Sure,
Record should
Landon
reflect the
is.
jury
She
has
usually
left the
sits
courtroom.
further back behind Al, though.
Set up however you want to set up, and just be ready to go when we get back. What I have told both sides is that my intent at this point in time is just to leave the TV on. I suppose there might be a need to switch back and forth between sources. Pardon?
That would just be on your end though, wouldn't it?
Right, yeah. So you,
Plug in from there.
Oh, so
And
it'd
if-
be the same
okay.
plug then.
Okay.
yeah, so you just need to tell me what the feed is from, but at this point in time, all of the evidence has been admitted. So I intend to, whatever is up there is going to stay up there until something else gets put up there.
Okay. Okay.
So any of this stuff that you want out, you need to move out. This is a suggestion. It is not a firm and direct rule because I don't want to interfere too much with what the attorneys intend to do during closing arguments. I think probably the poster boards are going to be best right there on that corner of the court reporter's table. So if you want to put something up there or hold them up there or prop them up on the table, that's fine. But if you want to do it over there or on the witness stand, I don't care. So I just wanted to let you know. With that, court will be in recess then.
All rise.
All right. Hopefully that's a little bit better view. I've been trying hard to get it to where we could see her up close, but yet clear. And that is proving really difficult today because the images coming from the court are so dark and blurry. But I think when they come back from a break, I will try so that we can at least see the judge, because I do like to see his reactions, especially when he rolls his eyes up and then looks up at the ceiling like, dear God, not more. I like seeing that. So I'll try to make the judge on the screen, but do him small, and then we can see the rest of the courtroom, including Leticia, much better if I do it that way, I think. But if you guys want to change anything, you just let me know, because I'm here for you, and I absolutely will do my best to change it. So yeah, the courtroom is dressed really sharp, lots and lots of blue for Gannon. That's wonderful to see. I'm not surprised though. Not surprised at all. Thank you, Deanna. So they are going to start with their closing statements when they come back from recess. And then they might have rebuttals after lunch, I believe is what he said this morning. All right, let's see if we can go back to finishing what they, Renee. Oh, did you? No, I didn't take notes on any of that. I will during the closing statements, though. Mostly that was just all the jury instructions. I'm with a few of you guys. I get a little woo and start, seeing squirrels and stuff during things like that. So we will count on the trustee reporters inside the courtroom. Okay, so going back to what I was going over earlier during the first recess was the recap of what happened and what went on Wednesday when we weren't able to hear much of anything. Let me get that back. All right, so when they came in from recess, I was saying one of the most important things that Leticia said. So let me go back just like a paragraph or two. She said, "I'm not a monster. I'm not a monster. People thinking I'm just a mass murderer and I just killed someone. Nobody ever thought she was a mass murderer. Under no circumstances did I know it was Gannon. I never knew it was him," said Stauch. In the video, Stauch then begins talking in what sounds like a Russian accent, saying there was someone in the home who was trying to hurt them. "You don't understand. I had to protect the people that were in the house. I had to protect them, and that's all I did," said Stauch. "I'm trying to kill. That's what I do. That's what I do for a living. I took the gun and fired the gun at someone who had a cape on. A dangerous man," said Stauch, who is now identifying as Maria. Dr. Lewis asked where she got the accent. Stauch said, "This is how I talk." She continued to say, "That's what I do. I killed the man. I will protect the people that I love. That's what I always do. I did what I was supposed to do. I killed a threat." So has Leticia never had any other threats in her life? This Maria only came out when Gannon was supposedly wearing a cape? I don't buy it. Dr. Lewis then acknowledges that it's nice to meet Maria. No, she also fist bumps her. Yep. And she goes to shake her hand, and Stauch fist bumps her. At the end of this clip and this part of the interview, a man walks out of the room following Tolini. Dr. Lewis was asked to identify that individual, and she says she cannot see. Young asked about that being her son. Young asked, "What is your son doing in the interview room?" Young questioned Dr. Lewis why her son was in the room during an evaluation in a first-degree murder case. Dr. Lewis said her son was running and operating one of the 2 cameras in the room. Jurors were shown part of the evaluation from the afternoon of November 17, 2022. This clip was an hour and 30 minutes long. The clip began with Dr. Lewis reading the confession in Latin, written by Maria. So this is when we couldn't really hear anything, right? Stauch said she gets flashbacks from the day that Gannon was killed. Yeah, right, Deanna? Kills for a living, but that was her only victim. So she gets flashbacks from the day he was killed. Blood, cape. I remember seeing someone in a cape. I remember a baby crying and then seeing someone in a cape. Stauch is identifying herself as Maria to Dr. Lewis. Why did she get rid of Gannon's body? Asked Lewis. She did not do that. I know a lot of people, said Stauch. You know, a lot of people. When asked about shooting the man in a cape, Dr. Lewis asked, did it turn out to be Gannon? Stauch replied, not until later. Later on, it was Gannon, but it wasn't supposed to be. I had to call some friends to help me out, to help get the body. Wonder what she meant there when she was saying that. Any guesses or just more mumbo jumbo bullshit from her? I tend to think there's always a little truth in every lie. So a lot of this, I think there was some truth in. What would you do if a man was in your home? Said Dr. Lewis. Probably run like hell, replied Stauch. I do different things. I have a special training in my past life. She is a sniper. When asked about shooting Gannon, Stauch claims she's her personality of Maria, saying, I don't care that I hurt people because it's for the good. I don't shoot crappy shots. My first thought was to get rid of the body. Now that I can believe. How do you feel about Harley? Questioned Lewis. That has nothing to do with me, ma'am. I protect Leticia, said Stauch. Tolini can be heard in the video asking, how did Gannon get all the cuts on him? Stauch replied, there was no cuts. I don't know anything about cuts. I did not know this. I did not cut anyone. So that was News 5, Ashley Portillo, and she is from Colorado Springs for KOAA News, and that was what she wrote to recap everything that we basically missed on Friday. I don't think this video will play. I've been trying to get it. It's been doing that the whole time I've had it up. Do you think she was being kind of honest when she said that she called in friends to help her get rid of the body? We know she didn't call like friends. So who's the one person she called? Yeah, exactly. I think that this jury is very smart, and I think that they are going to find her guilty. And I don't think they're going to find her insane either. Not that I won't be wrong. Sure, I'll share that. She does a very thorough job, this Ashley. She's also on Twitter. But there's a link to, it's a pretty lengthy article, but it was very in depth and well written. Really helpful since we all sat here for like 7 hours Wednesday and really couldn't hear much of anything. She heard the judge earlier. Excuse me. Oh, you're welcome. If she's found to be insane, she'll be made a ward of the state. But over time, if they feel like she has gotten better and what have you, she could be released. But I don't think that's going to happen. I think she's going to be in prison for her life, going to be found guilty and sane at the time. Peacock, I agree. I don't think she had anybody helping her. It was just something she said. I think Harley did help to the extent that we know. Sadly, I don't think Harley knew what she was truly helping with, which is horribly sad. I can't, imagine living with that. And even though we didn't, all of us kind of had a hard time paying attention to the jury instructions, they are super, super important for the jury to make these decisions. And no doubt they paid much closer attention than those of us here did. But I will take notes when they come back and they start their closing statements. Those are, to me, some of the best points of a trial. That and the opening, even though the defense's opening statements really sucked in this one. So they only have a few minutes left of their break. I'm going to take one real fast, and then I will be right back. You guys hang tight, okay? All right, I'm back. Told you that'd be quick. Is anybody following the Oklahoma 7? I made a post on my community wall when the 2 teenage girls went missing, and I've made another update or two to that, but I haven't actually covered it in any videos yet. Are you guys following that case? It just happened like a week ago. Horrific. So a lot of new stuff has come out in that case, including somehow a reporter was loud, did go inside of the man's home that killed them all and has video of it. So I've got quite the folder on that case. And I think after this, we'll start covering that. And it's only about an hour and a half away from me. So if for any reason it, would be helpful for me to go there, that's no problem at all. Super, super quick and easy trip. But yeah, the girls went missing. They were going to go help on a farm, ranch, whatever. And they went out there. And then the parents didn't hear back from them. They were reported missing. They knew who they were with, I believe. When they went to that guy's house, they found not only those two girls, but him, his wife, and his wife's 3 children, all murdered. 7 in total. That's in Oklahoma. All of the kids were under 18.
All right, court will call 20 CR
We're back.
1358, People versus
Here
Letecia
it gets
Stauch. Record
good.
should reflect the jury's not present. We okay? Okay. Jury's not present in the courtroom. Is there anything we need to take up outside the presence of the jury at this point in time? Prosecution?
No, Your Honor, thank you.
And you're good to go?
Yes,
Is your feed going to be prosecution table?
yes.
Okay. Defense, are you ready to go? And you're going to use his same feed?
I'm gonna use the
Podium? Okay. All right. All right. Let's go ahead and bring the jury in.
I'm going to mess with this screen real quick just to try to get a small picture of the judge. So if it looks wonky, that's what's going on.
It's just about a line. That's better. And if you're going to use the TVs, it's up to you as whether you turn the perimeter lights on or off. All rise for the jury, please. Thank you. You may all be seated. Court will recall 20 CR 1358, People versus Leticia Stauch. Record should reflect the jury has returned to the courtroom. At this point in time, we will start with the prosecution's closing argument. Prosecution?
Thanks, Judge. Morning. Been a long trial. You guys have sat through a lot of evidence, and you're gonna have to sift through that evidence and sift through the instructions, kind of what we talked about when we're selecting you, and apply the facts of this case to the law that you now have been given. Before I start my closing, I want to just say thank you for that. You guys have been very attentive. I can see that every day. You've asked some very good questions that I'm actually going to use in my closing argument as I go forward here. One of the things about a homicide case that is true and to form in pretty much every homicide case I've done in my career is the case kind of evolves to talk about the defendant. We spend a lot of time talking about the defendant. And then when you add that the defense is insanity, you even spend more time talking about the defendant. I want to come back to Gannon in a little bit. Gannon's been in a box back here for the whole trial. This is what the trial should be about. And I'm not doing this to get sympathy from you. I'm doing this to tell you that what Gannon had to tell you in this trial through the autopsy, all you need to know And when the defendant did what she did to him, saying at the time she did it. Not only do we know how he was killed and the effort and determination it took to kill him, we also know that his body was found in Florida. Body wasn't found in Florida. Do you think we'd be talking about insanity in this trial? It's a pure fact of divine intervention that Macon Ponder happened to be searching that bridge when he did. Remember, he said he searched that bridge every 2 years. Just so happened on March 17th, 2020, out there searching that bridge and he saw that suitcase. Dr. Lewis says it was crazy to drive a suitcase across the country and dump it over a bridge in Florida. Was it really? Think about the divine intervention of Gannon's body even being found to get here to where we're at right now. And the effort and determination that she took to hide his body. We're going to talk about that quite a bit more as I go through my closing. What I'd like to do now is talk about the autopsy and his injuries. I'm not going to show you any pictures. I'm going to tell you that right up front. I'm going to use the diagram. I wonder if we can have the TVs turned on. I can start with that. To describe his injuries, because his injuries are relevant. They're not only relevant to the crimes that she's charged with, the murder counts, but they're relevant to what her state of mind was when she committed those crimes. And so what we have up on the board now is People's Exhibit 144. You heard Dr. Ignacio testify. We showed you pictures of each and every injury that Gannon had to his body. This first diagram in People's Exhibit 144 kind of depicts the stab wounds. It also depicts the gunshot wound to his left chin area. Now, at least the group that I talked to in jury selection, we talked about every day of your life, you were trained to be jurors. That means you're using your common sense to make decisions, just like you're going to have to today when you go back to the deliberation room. Just by looking at these injuries, what does your common sense tell you? Without Dr. Ignacio's testimony, Gannon was defending himself. He was fighting off. Despite having hydrocodone in his system. Made him lethargic. He somehow was able to fight her off. The injuries to his fingers, the injuries to his arms. 18 times. 18 times she took a knife. The locations of the stab wounds. What does that tell you? Use your common sense. It's not psychotic. It's strategic. The stab wounds are to the chest. As Gannon's fighting, the stab wounds are to his back. But it's not just stab wounds. You know that. He has to use judgment and reflection to get another weapon. What that weapon was, who knows? But she got a weapon and hit him in the skull 4 separate times. Go to the next diagram. I forgot to mention the strategic stab wound to his neck just underneath his ear, which we see in People's Exhibit 145. The diagram doesn't do justice to the skull fracture that she caused in him. And I'm not going to show you pictures, but I think, remember those pictures? Completely obliterated the skull. The amount of force it takes to do that, judgment, reflection. The next exhibit shows the injuries that he had to the top of his head. 4 separate strikes to his head. Wasn't good enough. Wasn't good enough for her. So judgment, reflection, she goes and gets a handgun. She fires that handgun 3 times. I don't know how those bullets stayed in the pillow. We can rack our brain for ages. I don't know how those bullets stayed in that pillow. I don't know that we'll ever know how those bullets stayed in that pillow. What matters is the bullet that went into Gannon. That bullet matched the gun really she used that was still in the house. She attributed to Quincy Brown using, or Eduardo using, or whatever story of the day it was. Judgment, reflection, location of gunshot wound. Talk about make and ponder a little bit. Because as she drives to Florida, she checks in at about 12:22 in the morning, just after midnight, Candlewood Suites, Pensacola, Florida. Why do they drive all the way from Decatur in one night to get to Florida? Why does she want to get rid of Gannon's body in Florida? Gulf of Mexico. You drive this bridge at night, as Macon Ponder testified to, there's no lights on it. We know that sometime between, well, probably between 4 in the morning to 5 in the morning, she's out there. Look at the location where the body was found with the red arrow on People's Exhibit 63. More importantly, look at the space that she has to park this vehicle. I don't know where the pointer is, but you
Right
see.
behind you. It's right there on the window.
Okay, thanks. You can see the shoulder here, and there's plenty of room. Why does she park there? Because she can. 4 in the morning, there's no traffic out there. Does she think there's water underneath the bridge? Is that illogical thinking as you're crossing a bridge and you can't see anything? You cross a main waterway, the Escambia River, and you continue going until you find a place to stop. She probably had to wait that there was no traffic. It's with the body. Did you ever think the body was going to be found again? Go to the next slide. You see the suitcase underneath the bridge. And as Macon Ponder testified, it was where he and his coworker found it. It was clearly someone who dropped it directly over the bridge. There was an imprint that you remember seeing pictures of, and they ended up dragging it under the bridge, not knowing what the contents were. More importantly, not smelling anything. Why is that important? Charlie didn't smell anything. The body had been out here since February 4th. This is now March 17th in the Florida heat. They didn't smell anything until the suitcase was open. That lends some credibility to Harley when she says she never smelled or never knew the suitcase was back in the back of the van. Anyway, they dump it out and they see probably the most horrific thing anybody can ever see in their lives: Gannon's body in a fetal position, decomposed, wearing the same clothes that he was wearing January 7th, 2020. She killed him. Pants in a white stripe. Watch the video when they leave. See him wearing sweatpants with a white stripe. Talk about that more later. Let's talk about the law, okay? And as I go through the law, I'm going to later kind of go through the timeline of events. And I would like you to think about the mental states and sanity as I talk about those. So I want to talk about the law first. The first instruction I have up here is the elements of the crime of murder in the first degree after deliberation. You will see that most of these elements are not in dispute. That the defendant, not in dispute. In the state of Colorado, at or about the date and place charged, not in dispute. After deliberation and with intent, those are highlighted because those are the culpable mental states that are attached to that crime. Those are the culpable mental states in the insanity definition that we're talking about. So I want to highlight those in a second. To cause the death of a person other than herself, cause the death of a person, Gannon. Those are not in dispute either. And number 7 is the issue in the case. That's the insanity defense. I'm going to talk about in a minute. We can go to the next elements. After deliberation, not only intentionally, but also that the decision to commit the act has been made after the exercise of reflection and judgment concerning the act. An act committed after deliberation is never one which has been committed in a hasty or impulsive manner. Now, some of you, before you came into court, if you never seen this definition, you're probably thinking about premeditation, where people are planning something out and it takes days to plan out the murder and then they finally do the murder. That's not what that definition says. It's just enough time to have judgment and reflection, to make decisions. To go from grabbing a knife, to go to grabbing some blunt force object, to go to grabbing. Is she exercising judgment and reflection? And it doesn't have to be good judgment. It doesn't have to be bad judgment. It just has to be judgment. Is she making a decision? A person acts intentionally or with intent when her conscious objective is to cause a specific result prescribed by the statute defining the offense. It is immaterial whether or not the result actually occurred. I don't want to bet money on it, but I bet you a lawyer wrote that definition. It just means with intent. What was their intent? Did she intend to kill Gannon when she did what she did to Gannon? I would suggest that that's not in dispute either. We can now go to the next crime, which is murder in the first degree, a child under the age of 12, and the defendant was in a position of trust. Now, the reason why there's 2 counts of murder, there's only 1 victim, is because this is just another theory of first-degree murder. There's several theories of first-degree murder in the law. These are the 2 that are in front of you now, okay? And as you can see, the mental state is what's different, and the age of the victim. And then the defendant has to be in a possession of trust. That's not in dispute. She's stepmom. She's obviously acting as Gannon's parent at the time that she. But let's talk about what knowingly is, because that's the culpable mental state with this crime. Person acts knowingly or willfully with respect to conduct or to circumstance described by statute defining an offense when she is aware that her conduct is of such a nature or that such a circumstance exists. A person acts knowingly or willfully with respect to a result of her conduct when she is aware that her conduct is practically certain to cause the result. Stab someone 18 times, hit him over the head 4 times. When you shoot at him 3 times, striking him once, I think you might have an idea of what the result might be. I would suggest that that's not in dispute in this case. Let's go to insanity. These words mean a lot. This is not something that you're going to find in the DSM-5. This is not a mental illness. This is a legal definition. These are just like the elements of the crime that we just went through. The reason I say that is because, first of all, I'm going to start at the bottom. It says the law presumes everyone to be sane. There's a presumption of sanity. However, after some evidence of insanity has been presented, the burden of proof shifts to us, and we gladly accept it. Gladly accept it. Now, what does insanity mean? The defendant was insane at the time of the commission of the acts if he was so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to the act. That's why you heard me ask that question so many times. Or she suffered from a condition of mind caused by a mental disease or defect that prevented her from forming a culpable mental state, the ones we just talked about, that is an essential element of a crime charged. And then the next paragraph means something. Because it says, but care should be taken not to confuse mental disease or defect with moral obliquity, mental depravity, or passion growing out of anger. Passion growing out of anger. If you lose your temper, you don't get to claim insanity. Revenge, hatred, or other motives and kindred evil conditions, because when an act is induced by any of these causes, the person is accountable to the law. So you can't lose your temper and come in and say, I lost my temper, I wasn't myself. We're humans. We have emotions. The next part is what's critical. It says, in addition, disease or defective in mind does not refer to an abnormality manifested by only repeated criminal or otherwise antisocial conduct. We heard a little bit about antisocial personality disorder. Who hasn't been diagnosed with that, but that's the reason why someone who has antisocial personality disorder, they have fun killing people, they lie all the time, they manipulate all the time, they have no empathy, they have no sympathy. Those people don't get to come in and say, I was living insane. Now, what does mental disease or defect mean? This is what the legal definition of mental disease or defect is. And I'm going to leave this up here for quite a while because I'm going to go through all the doctor's testimony here in a second. And I want you to look at that instruction as we talk about what they had to say. But first of all, it has to be a severe word means something. It has to be a severely abnormal mental condition that grossly and demonstrably impairs a person's perception of understanding of reality and that are not attributable to the voluntary ingestion of alcohol or drugs. Mental disease or defect does not include an abnormality manifested only by repeated criminal or other antisocial behavior. So let's talk about that. The word grossly and demonstrably. You think Harley might notice if she had a grossly and demonstrably mental condition? You think she might have shared that with you? You think Al Stauch might have noticed when it says it has to be grossly and demonstrably? He's got to demonstrate it, right? It's not something you snap your fingers and then all of a sudden go into a different personality. What about her brother? Howard. Think he might have noticed it? Let's talk about the doctors. I'm actually going to talk about Dr. Niederhauser first. Dr. Niederhauser was really the first doctor and all the doctors that you heard from to see her. If you recall, she saw her on December 5th, December 13th, 30 minutes each time. Came in and remember the difference between a clinical evaluation and a forensic evaluation. Clinical evaluation. I rely on what the patient says. I rely just like if they came in and said, I've got a fever. I'm going to take that at their word and I'm going to treat them for what they're telling me. She comes in and says, I've got anxiety. Treats her for anxiety. She diagnoses her with general anxiety. And she told you on the stand that she had general anxiety at the time she's testimony. A lot of people did that came in and testified. That's not a severe and abnormal mental condition that grossly and demonstrably impairs a person's perception or understanding of reality. We all experience that. You got to experience her experiencing it on video. In January 20, when she's being interviewed, remember at the end of the interview, she had to call the paramedics and she said she was suffering from panic attacks. The paramedics came in and said, your vital signs are good. You're breathing fine. Your heart rate's fine. I don't know what the problem is. Think she might have been faking that to get out of the setting? Dr. Niederheiser also tells us that she had no history of inpatient psychiatric treatment, no history other than anxiety of any other diagnosis for mental illnesses. And this is based on what the defendant's telling her. No evidence of psychosis. No reason to put her on an M1 hold. If she was experiencing psychosis in December of 2019, the doctor would have had an obligation to come in. That's the kind of stuff that talks about severely abnormal mental conditions that affects your vision of reality. It's not there. The other thing about that visit, the timing of that visit, December of 2019. Remember, the whole purpose of that visit is so that she can get a letter to go to her employment because she didn't want to work anymore. The ironic part about it is at the second interview, the defendant tells her, I don't want to work there anymore. But I got a contract, so I need a letter to get out of it. But what else happens right before Gannon is murdered? He goes on a cruise. He goes on a cruise in January. You think that might have something to do with not wanting to go to work? Based on what you know about her and the statements she's made? Dr. Moore, Christine Moore, she works at the jail. She's a psychologist. She evaluates people who come in who are charged with serious crimes, perhaps their first time in a jail. They evaluate to see if they're a danger to themselves or others. It's a psychological evaluation. She said it was a clinical evaluation. They also want to know if there's any medication they might need. What the defendant tells her is that she has anxiety. I didn't do the crime, not going to be a problem. That was on March 5th, 2020, first day of her visit in the jail. Dr. Moore spent quite a bit of time with her up until January 5th of 2021, seeing her either once every 2 weeks or once every week, depending on what was going on with her. March 20th, she goes to her and says, I just want to see how you're doing. And his body was found. Never in Florida. The reason why I'm telling you this is because she doesn't say, hey, Maria Sanchez did it. Or, you know what? I got dissociative identity disorder. You're a psychologist. I need help. Nothing. In fact, she told you there was no evidence during the entire time she spent with her that she had dissociative identity disorder or any other severe mental illness that meets that definition. This was it was a little over a month after the crime, January 27th to March 5th. And then what happens on June 5th, 2020 in the jail? You recall Dr. Moore's testimony. She reviews all the deputies' notes to see what's going on with the defendant at the time, to see how she's doing. And she reviews notes from deputies that say, I'm going to start acting crazy. That's what the defendant says. And then on that very day, June 5th, 2020, she enters a competency issue into the court. That's how we get to the competency evaluations that I'm going to talk about here in a second. The timing of that. Okay, Gannon's body was found on March 17th. She finds out about it on March 20th. You know that she's read the discovery, the police reports in this case, and there's nothing wrong with that. She's entitled to read that. Point is, she's read it. And then all of a sudden, I'm going to start acting crazy. For another defense, No dissociative identity disorder, certainly no Maria Sanchez during her entire time or entire visits with Dr. Moore for that year period of time. The first competency evaluation was done down at the state hospital. You don't pick where she goes. The prosecution, when I say we don't pick what doctors do the evaluation. Court orders it, goes to the state hospital. Doctors are chosen, they do an evaluation. What's relevant about this first competency evaluation that takes place on July 20th, 2020 is when she goes to the state hospital, is that they have a 2-week observation period. For nurses, employees are watching her. He actually goes to a nurse and says, can you tell when someone's faking it? Dr. Torres and Dr. Gray actually they do a forensic interview with her on August 4th of 2020. Again, now we're in a forensic mode. Now we're not just going to listen to what she has to say. We're going to look at collateral information. We're going to call Al Stauch. We're going to try to call Harley. We're going to try to call family members to see if we can corroborate what she's telling us. So what does she tell them? I've got bipolar disorder. I'm a manic depressant. I ramble. I'm a manic depression. That's my mental illness. Nothing about dissociative identity disorder, which according to Dr. Lewis, she's had it since a very young age. Nothing about Maria Sanchez. Remember Dr. Torres' testimony when she was talking about the competency evaluation? One of the psychological tests that she took had a question about multi-personalities. And the answer led Dr. Torres to ask her, hey, do you have multiple personalities? This is August 4th, 2020. Dr. Gray and Dr. Torres diagnosed her with specified personality disorder with borderline and narcissistic features. Talked about that a little bit. Now, does it meet that definition? How do we know if it meets that definition? Her actions, how other people perceive her. Also, Dr. Torres said you, no, it's not a severe mental disease. It's not something that affects her everyday life, that affects her ability to make decisions. No evidence of psychosis during that evaluation either. No history of inpatient treatment during that evaluation. Psychological testing. MMPI-2. Remember that test? What does that test tell you and told Dr. Torres and Dr. Gray? That she exaggerates psychiatric to the point where even people who are hospitalized for their mental illness don't answer questions that way. You think she might be faking it? Now we go to the second competency evaluation with Dr. Grimmett. Now, remember how Dr. Grimmett became involved in this case? The defense at the time, and it wasn't these defense attorneys, requested that she do the evaluation of the second competency evaluation. We had nothing to do with that. So now this happens on December 22nd, 2020. That's when Dr. Grimmett talks to her. And so I want you to think about how it's progressed now. Now she starts talking about dissociative identity disorder and bipolar disorder. When I say she, the defendant. That's what the defendant is telling Dr. Grimmett. She says she has 4 distinct personalities. None of those 4 were Maria Sanchez. Remember what Dr. Grimmett testified to? That she was, first of all, creating these names. Second of all, like Jasmine was a Disney character. talked about vampires. Twilight. I've seen the movie Twilight. I know I hate admitting that, but I've seen it. And she cited the characters from that movie. And Dr. Grimmett said, wait a minute here. You're just telling me characters from a movie? That's not dissociative identity disorder. But she evaluated her for it because that's what she's telling. Dr. Grimmett evaluated her for DID. Said, no, not there. I don't even need any more information. I don't need to rule it out. Not there. She also diagnosed the defendant with other specified personality disorder with borderline and narcissistic features. She also told you that it doesn't fit that definition. Jump forward to February of 2022. I don't know when the conversation took place, but at some point before the defendant pled not guilty by reason of insanity on February 11th, 2022, they had a conversation, the counsel had a conversation with Dr. Lewis. Remember, Dr. Lewis testified that I recommended you change your plea to not guilty by reason of insanity. Why is that important? Why did I ask her about that? I think that put a little pressure on her. And she says, I recommend you plead not guilty by reason of insanity, and I'll do the evaluation. Why didn't she do the evaluation right away? Why'd she wait till November? Come out and talk to the defendant. Needless to say, when she pled not guilty by reason of insanity in February, the same process happened as happened when she raised competency. Sent down to the state hospital. The state hospital chooses who's going to do the evaluation. They make a decision on who already knows the case. Dr. Torres and Dr. Gray already read all the discovery in this case. They knew the facts of the case. They knew the defendant, but they're doing a different evaluation. As you remember, competency goes to her state of mind at the time they're doing the evaluation. What's her understanding, what's happening in the courtroom, whether or not she can get along with her attorneys, that kind of thing. Insanity is completely different. Insanity, you got to go back, just like the law says, at the time of the crime, what was her mental state? So that's a much broader evaluation. You got to look at everything. So Dr. Torres and Dr. Gray, they also reach out again, call out. They attempt to talk to Harley, family members, to see what's going on with her. But what is the defendant saying now? Gone off of bipolar now. And now she's created more personalities as part of this dissociative identity disorder. Is it just a coincidence that she's consulted with Dr. Lewis prior to all this? Now Maria Sanchez comes into play during this evaluation. Dr. Torres testified, and it's in a report, that she said, there is no credible evidence to conclude she has a condition that conforms to the definition of a mental disease or defect. Pretty powerful language. That's powerful language. No credible evidence. What's also interesting about this evaluation compared to Dr. Lewis's evaluation is they do two interviews, if you remember. One was in March, one was in June. The March interview, I think I couldn't count how many questions, but it wasn't a lot of questions asked. It was the defendant talking. They just let her go. In June, they asked more questions. One of the questions that Dr. Torres asked is, can we talk to Maria? Can we talk to Maria Sanchez? She said, no, Maria just doesn't come out. There's got to be some kind of stressor. There's got to be a triggering event, which coincidentally is exactly what the DSM-5 says. I can't just summon Maria. You saw on Wednesday how that happened. And it was magic, according to the Dr. Lewis. No severe abnormal mental conditions that grossly and demonstrably impair a person's perception of understanding of reality. No psychosis, no bipolar, because remember the first competency evaluation, they said they had to rule it out. They've ruled it out. Bipolar does not exist with this defendant based on Dr. Torres and Dr. Gray. They also said no dissociative identity disorder. Didn't have to rule that out. They had enough to say there's no credible evidence. That's not there. They continued on with the diagnosis of other specified personality disorder with borderline and narcissistic features. Dr. Torres and Dr. Gray came to the conclusion that the defendant was not legally insane at the time of the crime. Let's go to the next slide, which is the credibility instruction. This instruction applies to experts as well. You may believe all the testimony of a witness, part of it, or none of it. This instruction applies to every witness who testifies, including Dr. Lewis. I've got highlighted certain words there. Motive. Didn't see motive in the elements of first-degree murder, but you see it here. Money is a strong motivator. Having shows on HBO, strong motivator. Having your son videotape evaluations on a first-degree murder case that's gotten quite a bit of publicity, or perhaps another documentary, is motive. You're gonna do a documentary if she says she's sane, sorry, did what I could. Acting. Not as good as, well, not as bad as Robert De Niro, I guess she would say, but she's acting. You also have to look at her demeanor and manner while testifying. She wouldn't answer any of my questions. She wouldn't answer my questions because she didn't want you to know the answers. She wanted you to know what she wanted to say. She shows up to court late. Talk about narcissistic tendencies. Manner while testifying. I think that speaks for itself, how she testified. Especially when you compare Dr. Torres. Obviously she would disagree with my questions. Remember how many times she says it depends to me? She's not our expert. This happens to be the expert that the state hospital chose to come in to do a neutral evaluation. The truth. Dr. Lewis. She didn't know the legal definition of insanity in the state of Colorado, ladies and gentlemen. The whole reason she came in to testify. I'm not even sure what her opinion is anymore based on your questions at the end. Remember how she answered it? About the MRI and the EEG that she withdrew? My opinion is ongoing. What does that mean? Does that tell you that her opinion that she was legally insane at the time counts for anything? Because when you think about her report, she does this preliminary report, which was supposed to be an insanity report, 35 days before trial, that says, hey, I need more information. I need an EEG and an MRI done if I'm going to make a decision on insanity. Well, that doesn't happen. MRIs, you take someone to the hospital for 2 hours, you do an MRI, you come back. Never happened. But yet, a few days before trial, she hands over a report saying, I find her legally insane, and that's literally all she says. Don't know what standard of insanity she's using. What I do know is she didn't get the information that she needed. But you know what information she had? She had a third MMPI-2 test that Dr. Torres told you about, that a Dr. Leach took that was hired by the defense to do psychological testing based on what Dr. Lewis requested. Guess what the results of that showed? It was the same, exaggerating psychiatric symptoms to the point where people who are hospitalized for mental illnesses would not answer those questions that way. Just
Two, I just don't know what to do.
Well, devastating. Initially, Scott, I can't lie when the TMZ information.
Gannon, I promise this is the last time I'm gonna ask you. I'm just freaked out, okay? Are you sure you didn't do it on purpose? Okay, you promise. You promise. Pinky promise. Okay, all right, so listen. All right, we're gonna have to sell stuff to fix it, okay? So we figure out what we gotta sell. We can sell the sofa. We can sell whatever, because we gotta get it fixed. So lady, don't be mad at us and kick us out of the house, okay? You got it? You got it?
I'm just worried about my.
Okay, shh, listen. So tomorrow,
why is that important? Why is she videotaping an 11-year-old boy who has burns? More importantly, why did she stop videotaping a little boy, Gannon? I think it might be because Gannon said, "I'm just worried about my burns." I think that was the purpose of that video. I think that's using judgment and reflection. Now, the hydrocodone. I can't stand here and tell you how that got in the Gannon system. All I can tell you is there's only one person there that could have. Did she give it to him because of the burns? I don't know. But when she gave it to him, do you think that's using judgment and reflection? January 27th. This is actually at 9:46 is when this video was recorded. Monday night. The next morning, January 27th, 2020, at 4:36 in the morning. Decision was made for her, or she made the decision to text Nick Hicks saying, "My stepfather had just been killed in a car accident." Or words to that effect. Ms. Hicks responds later on saying, "I'm sorry, please let me know." And I'm paraphrasing, I don't have it memorized. But she says words to the effect, "Please let me know if there's anything we can do and when you can come in." She responds back, the defendant does, by saying, "Why are you being so insensitive? This is a family member that just died on the East Coast." Why is that important? Because that's the theory that Dr. Lewis wants you to believe. The fact that she makes this text about the stepfather is somehow tied to the killing of Gannon. Some years later. It just means she didn't want to go to work that day. Could it possibly mean that she knew what she was going to do when she said, "And tomorrow"? And shortly after that, she calls Gannon school and says, "He's not coming in today." And she texts Al Stauch and says, "Hey, I'm going to make up an excuse, not go to work," which she does. And Gannon's not going to go to school because of his stomach issues. Judgment, reflection? Then on that same morning at 8:14 and 8:16 a.m., she takes that picture of Gannon in bed. Why did she take a picture of Gannon in bed in his bed? And text it to Gannon's father, Al. Look, Gannon's alive. He's here, he's sick, he's in bed. You heard Al Stauch testify a little bit about Gannon. He has ADHD. Hyper. It's still at 8:14, 8:16. Think he might be lethargic from hydrocodone? Why he's still in bed? Think she wants to prove that he's still alive because she knew how much hydrocodone she gave him? Is that a rational reason to do it? Does that make sense? January 27th at 9:54 a.m. Text Al from her phone. This was your question, by the way. She texts Al from her phone saying, I left my phone at home before she left the house. You think that's an indication that she knew what was going to happen? Is it that far-fetched to think that she knows Gannon had been poisoned and that something might happen to Gannon? Then at 10:12 a.m., they leave in Al's truck. And again, this is the video that you saw that you can see his pants with the white stripe down him when they leave. You see him get into the back seat of the pickup truck, and Stauch gets into the driver's seat. They drive away. What the heck is she doing taking a sick kid out to go shopping for dog clothes? Narcissistic tendencies. Not me. Dogs. They're gone until 2:20 p.m. when they come back. You saw the videos. She drives in the back of the driveway. She's got to back in and then drive back in. Eventually the truck comes to a stop. They're stopped in that driveway for 39 seconds. What are they talking about in that truck? Doors open. You see the leg drop. You see Gannon beeline right through the garage. You see the defendant going after. At 2:26 p.m., you see the defendant come out and move the Tiguan from the driveway, back it into the garage. What was the need at that moment to back that Tiguan into the garage? Then you see her come out in the front of the garage, out in front, below the garage door, and look around. Back in the house. This is when the murder happens, ladies and gentlemen. 30. Right in that time frame. There's no activity on her phone. And does autopsy. Axe him with a knife. Good enough. And he fought when he was born. He's fighting now. On 1 pound, 6 ounces. Get it through that. Coming after him. Goes to get a blunt force object, crush his skull. Not sound like rational thinking, but it's certainly thinking. It's the before and during. A lot to talk about. There's so much to talk about after. She stuffs him in a suitcase. She drags his body to the storage room, opens a large green suitcase, somehow manages to squeeze him in there, gets the blankets off the bed, wraps him up in that, pillows, picks up the shell casings, does something with a knife, does something with a blunt force object. She sticks them into the storage room and throws boxes on them. At 11 p.m., Al texted her, said, "Are you sleeping?" No response from the defendant. Lena gets home. She gets to the house about 3:15 p.m. The bus comes by about 3:11 p.m. Doesn't let Lena in the house. She makes Lena stay outside because she's got work to do. Got to clean that bloody mess in that room. Got to hide evidence. Got to tamper with things. Gannon's dad texted him at 3:35. Said, "Hey, buddy. Having no clue what she did to him." No response to that. No one read that text until 7:40 that evening. That was the defendant reading it. 6:27 p.m., the defendant texts Al and says, "Gannon went to a friend's house. He was supposed to be home at 6. He's not home yet." 6:55, she calls 911. You heard that call. How can she do this? How can she talk to Gannon's father like nothing happened? That traits of an antisocial personality disorder, the fact that you can have no sympathy, go cold and callous, and act like nothing happened. And she does it through the whole day. You guys know that. She calls Landon on Gannon's phone a couple times that night. Is that a trait of an antisocial personality disorder? Landon gets a call from Gannon. She knows he's missing, and it's her. Next morning, January 28, 2020, at 6:22 a.m., you see the T-Bone leave. It's gone for 10 minutes. What is she doing? Is it beyond the realm of possibility that she's doing a practice run to see if anybody's watching her? She's about to move the body. Is that beyond the realm of common sense? She again comes back, backs into the garage. Heard evidence that she'd never backed that T1 in the back of the garage until that day. They leave. When I say they, Bandit and Gannon's body. Go to the airport. Leave the house at 8:13 a.m. They get to the airport about 8:30 a.m. She's made the decision to rent another car. She even left the house. Is that evidence of psychosis? Or is that evidence of thinking things through? I'm going to leave Gannon's body in the back of that T1 at the airport. We're going to pick up a car. Al's didn't care because we don't want to put mileage on my leased vehicle. Al gets off the airplane. He's just worried about Gannon. Where's my son? You think at that moment he cared that she rented a car? But she made a big deal about, hey, I don't want to put miles on my T1. She never searched for Gannon anymore. They go to the interview at Starbucks at approximately 1:30 that afternoon. They had that interview, you heard it. After that interview, she disappears. She takes the rental car and it's gone that afternoon. No one knows where she's at. We do. Is that Life 360 app? We got her going back to the airport at 4:41 p.m. We have a parking ticket that was found inside the white Kia rental car that says she went into the airport at 4:41 p.m. Now, she must have got out of there quickly because she never had to get another ticket when she left. But we know from Life 360, and we know from the telegraph on the Tiguan that the Tiguan didn't leave, that she leaves the airport shortly after that. What is she doing at the airport? Is it that crazy to think that she's checking on Gannon's body in the back of the Tiguan? That sound like someone doesn't know right from wrong? That sound like someone who's trying to get away with something. At some point that afternoon, as Al Stauch is out looking for his son, he goes to French elementary school. And he goes there because his wife, the defendant, says, I left the Tiguan there. That's a critical moment in the investigation because when he sees the Tiguan is not there, he now knows that his wife had something to do with the disappearance of Gannon. And the investigation starts to look at her. Because he has a second interview that night, he tells the police, you know, I didn't think much about that rental car until I went to French Elementary and I didn't see the Tiguan there like she told me it was. At 5:25 p.m. that night on the 28th, she tells Al Stauch, you need to get an attorney. Seven p.m. she returns back to the airport. She parks that white Kia in short-term parking, keeps the keys, and drives off in the Tiguan and exits the airport at 7:03 p.m., very close to that time. Got the ticket. You've got the ticket. We got the telematics and know exactly where she goes. Got the text messages between her and Harley. Just clearly show that she's manipulating Harley, her own daughter. Don't let the police in. Don't talk to the police. The pizza guy? All right, you can let the pizza guy in. If she's manipulating Harley, do you think she's manipulating Gannon? Do you think she's manipulating Lena? Do you think that's manipulation, the video you just saw? You're gonna have to sell stuff because the lady's gonna be upset with this, the owner of the house. Goes to the S-curve in Palmer Lake. You know that at 9:23 p.m. She's there for at least 5 minutes. We don't know why actually she's there. We know that the board was found there sometime in mid-February when we started searching there based on the information we had from our Life 360 and the telematics. We know that board had Gannon's blood on it. DNA matched it. Why is she going out to hide the body there? I don't know. Probably because it's a good location. She can't keep it in the Tiguan. She know right from wrong? At 12 a.m., 28th into the 29th, Harley drives out to her employment to pick her up. They leave the Tiguan there overnight. This whole time while she's missing and dumping Dan's body up in Palmer Lake, Detective Bethel is trying to get her to come in for an interview. Remember that? Al Stauch's trying to call her to get in for an interview. Her phone's on airplane. The next morning, Harley drives her to the airport. They drop off the keys to the Kia. When I say drop it off, they threw the keys to the Kia to an attendant, left. That rational thinking? That someone who didn't want to get caught? Text at 10:25 a.m. on the 29th. I'm on my way to Detective Bethel. The interview. Takes her over an hour and a half to get there. We know that the car is washed on the way. You saw photos of the water dripping off of it when she gets there. The interview she gives, you watched it. I'm not going to get into all the details. I just want to emphasize that she plants seeds. The suitcase is critical. Who says that? I think it was Eduardo at this time. Eduardo also took a suitcase when he took Gannon. She knows where the suitcase is at up in Palmer Lake. On January 30th, 2020, her family shows up. Dakota Lowry, Brenda Awkward, and Deborah Locklear, her mother. Flying to Denver, they rent that Nissan Altima and drive down to Colorado Springs. They pick them up. take them to the extended stay suites hotel. The next morning, they rent that van, Brenda Awkward does, to collect their stuff at the house. They get her suitcase, including that red or pink suitcase that we recover in South Carolina that has blood on it that happens to match Gannon, with a blanket inside it that happens to match Gannon. Pretty strong evidence. You got blood of the victim that you just killed with you when you're arrested on March 2nd. But what happens after they load things up? We know the suitcase was not there because the police were checking everything that came out of that house. We also know what Dakota said about when they exchanged vans, that he saw that very same green suitcase that was under the bridge that day, and she says she had softball equipment in it. But when she gives the interview with the KKTV reporter at 12:10 p.m., well, let's just look at her words. What are her words? We can play this video.
You are.
I am Letecia Stauch, which is Gannon's stepmother.
You've been a part of the investigation since the very first time. You were the last person to see him. Is that right?
Correct.
What did you see when you last saw him?
Well, I'm not allowed to talk about anything with the case. I would more so be willing to talk about how the community needs to have faith and continue to work together and not make these false accusations. And I would never, ever hurt this child. And I know there's some questions out there about, okay, so tell me what happens. That's up to the investigations when they end up letting you guys know. But I've cooperated with them, even to the point that we were held with a gun. And my daughter, a 17-year-old who serves our country in the United States Air Force, who has never committed a crime or done anything wrong in her life, was put in handcuffs over the keys that was in her purse so they could take her car. I'm just ready for Gannon to come home. Most importantly, for him to see his family. But second, I am going to be so ecstatic when I'm able to say to people that I hope they have a really sincere apology for all these theories that have came out online, for all the things they said that I have done or people have done. And I just want everyone, we're going to find Gannon.
Can you talk to me a little bit about him? I don't know it.
Gannon is so kind and he loves to play video games. That's one of his favorite things. He loves Sonic and Mario. And, you know, he's always helpful. And he was always so helpful with the dogs around the house. And we have 2 little cute dogs. And he was always like a person I could say, Gannon, can you go do this? And he would do it right away. You know, sometimes with kids, we have to remind them and things like that. And that's okay. But he was so sweet and able to help anyone. He could notice when you're sick and say, are you okay? And such a kind heart. We should all come together and wait until the end and see what happens because Gannon's going to come home.
Any message for Gannon?
The message for Gannon I have is, Gannon, when you get here, you'll be able to truly tell what happened. And then I really hope I get a sincere apology from everyone who has made all those things, especially from my husband.
What we just heard there, that evidence that she might have some antisocial trait. Calmly talk about that to a news reporter. She's done. I failed to mention Amanda Van Nest, who was the same nurse who examined her for injuries based on what she was telling people. First interview that she was raped and she examined her head and found no injuries. But what else did she do? She also told you about M1 holes. And if she would have noticed anything that would require her to have a doctor examine her for an M1 hold, she would have done it. No evidence of mental disease. No evidence of psychosis. And this is the 29th, 2 days after she killed him. We know that a GPS tracker was later placed on that Nissan Altima, and you know where she went when she disappeared for 2 hours and told her family that she was going to a pet store. Got her right back at the Isker. She picks up Gannon's body, puts him in the trunk of that Nissan Altima, leaves the board out there, later found, and drives back to the hotel after she goes and gets some more dog outfits. And when she gets back to the extended stay suites, she's got to move Gannon's body from the trunk to the van that Brenda Awkward rented earlier that day. We know that had to happen because of Dakota Lowry's testimony. Her and Dakota go to the budget rental van place the next morning, February 1st, and they've got to move all the suitcases from one van to another. That's when he sees the green suitcase, knew something was suspicious about it. You saw his reaction. Had to get on a witness stand. He got subpoenaed here to come here. I think he felt manipulated by this defendant. You know the rest of the story. She drives across country with Harley. She's using the Ford Motor Company to check into hotels. They got a little scheme you saw in video. Harley would go in with the dogs. She'd check in as one person. All rational thinking. It's also by social personality traits, perhaps. They drive all the way to Florida. They get there February 4th. Another divine intervention. The power up at 4:36 in the morning in between the hotel and where Gannon's body is found. Every 24 or 25 hours it happens. It happens at that moment. That tells you that van is on the move in the middle of the night. Tells you she dumped Gannon's body that night or the early morning hours of February 4th. I'm going to go through fast now because I've been talking way too long. When I talk about the pretext phone calls, you know all the stories. I'm not going to get into the details. Eduardo, immunity, Quincy Brown, several different versions of that. Bike accident, Uncle Matt. One that significant, and she says, I'm so sorry, Al, for lying to you. I'm going to tell you the truth. I wasn't in the car when I left Petco. It wasn't in the truck. Fake pregnant lady with cash. She's laundering money. She's arrested on March 2nd, 2020. She comes up with a story of now how it's Angel, the babysitter, who did it. Suitcase with Gannon's blood found on her. We've got all the searches on her phone that I'm not going to go through. You just saw it a few days ago. But what I'd like to talk about is what people who are truly legally insane do under these circumstances. Because there are people who are truly legally insane, ladies and gentlemen. They don't act like that. If they don't have the capacity to know right from wrong, they're not going to hide the body. They're going to act like nothing happened. They may even do the crime if someone's there watching them because they don't know that it's wrong. Do you think she would have done this to Gannon if anyone was in the room with her? Of course not. They also don't lie. There's no reason to lie because they don't think it's wrong. So they come in and they say things like, my God, I heard a voice that I thought was the devil. And the devil made me do this. I had no choice. Why are you even talking to me about it? That's what we're talking about when we talk about a severe mental disease or defect. When we're talking about the capacity to form the intent or the capacity to use judgment and reflection, I'm going to refer you back to Mice and Men, the book. I read that a long time ago, but I still remember it. It's about George and Lenny during the Depression. And George is a smart one. Lenny has some severe mental illnesses. Lenny likes to pet rabbits. He's such a big guy that he doesn't even know his own strength. So he would pet rabbits to the point where he would kill them. That's what we're talking about when you don't have the capacity to form the intent to kill because the mental illness doesn't allow you to. We're not talking about someone who makes choices to get weapons to kill with. I appreciate your patience. I know I've talked a long time here, much longer than I thought, and I apologize for that. There's only one right verdict in this case. That's guilty to each and every charge that she's charged with. first degree murder after deliberation, first degree murder, child under the age of 12, tampering with the deceased body, and tampering with physical evidence.
That was pretty powerful, I think.
Can we switch over?
Yeah, I did.
Like, how do you even argue with anything he just said? All the evidence is there.
Oh, whoops, wrong one. Sorry, my bad.
Thank goodness it's this attorney doing it, not Loverboy over there.
The one thing they cannot answer, because there is no answer, is motive. Motive for why this happened. Motive how we can go from this picture on a hike up at Garden of the Gods, loving, kind, to less than 24 hours later. Brutal rage. 18 stab wounds. 4 blunt force trauma. Shot. This wasn't a pre-planned, calculated killing for some gain. This was a psychotic break fueled by rage, attacking a demon from the past. They cannot come up with a motive because there is no motive that makes sense, ladies and gentlemen. They have tried. They have spent hundreds, if not thousands of hours trying to come up with one. They have gone through phones. They have gone through iCloud accounts. They have gone through Facebook messages. They've interviewed everybody who they could possibly think of to try to find some motive. None of what they have done in this, the biggest investigation in the history of El Paso County, has come up with a motive. No one who they have ever interviewed has ever said that she ever had a problem with Gannon. No one who they have ever interviewed has ever said she was ever mean to Gannon. No one who they've ever interviewed or come across anything has said she's ever done anything wrong to Gannon until that horrible day when this happens. That is the evidence, and the most strong evidence to know this was not premeditated murder. This is a psychotic break. That is the only thing that makes sense. And when you can pull yourself back and peel back the layers of the anger over the act, at the anger over the deceit in which it happened, at the anger over Gannon's body being driven all the way to Florida, when we take those emotions back and we try to look at this rationally, the only thing that possibly makes sense is a psychotic break. There is no other rational explanation to understand why this happened other than that. He was a special needs teacher, elementary needs teacher. That's what she'd been her entire life, working with kids with special needs. She was a mother to Harley, did everything she possibly could for Harley. She was a wife to Al, and she was tried to be the best stepmother she could be these kids. So much so that she was left with the kids for very long periods of time. In the months preceding this, when Al had gone up to Alaska, he had left his 2 kids in her care. He was gone. We were about as far across the country as you could possibly get. And based upon his relationship with her, based upon him seeing her as a loving stepmom, felt comfortable leaving his children with her alone in South Carolina. And he did that because he knew her and he saw her and he saw that relationship she had with Gannon, and he felt comfortable based upon what he had seen with her. And he felt comfortable enough that when this was going on, he felt comfortable enough to leave to go to Oklahoma. Because what he had seen and what this photo shows is they had a loving relationship together until the evidence shows that she had a psychotic break. That something, mental illness from her past, got triggered, and there was a temporary period of psychosis. That's the only rational explanation that had been presented. And there is nothing else that they can come up with as far as motive. Ladies and gentlemen, does it make sense that she may have Google searched maybe moving to Florida? Yeah. People have problems in marriages, facilitate that move. It wasn't. There's no rational basis behind the murder other than psychosis. The fact that she may have years before at some point in time done one Google search out of 1,000 saying, I don't like my stepson. That's not what I see there in that picture. That's not what I see there going on in the days leading up to this horrible tragedy. What it does seem to indicate, ladies and gentlemen, if we start looking at this time frame, looking at the reliable evidence that we have in front of us, is that somehow that fire set off some type of trigger. Maybe some type of trigger that had been disassociated long ago. But we have her starting meltdown right after this fire. Ladies and gentlemen, Dr. Lewis used the term wacky a lot, maybe not the most scientific term, but when something seems irrational, when something doesn't seem to make sense, we have to consider mental illness. We have to consider possible psychosis. I would say that video that you heard up there, listen to the tenor of her voice, listen to what she is saying. She says, I'm freaked out. And when you listen to her voice, she is freaked out. And she's saying irrational stuff like, we're going to have to sell the sofa. Stuff like that to Gannon. That makes no sense there whatsoever. And then importantly, ladies and gentlemen, we also see mania starting to settle in when we start looking at these timelines specifically. We up there, they're texting back and forth, 10:15, Harley comes home, 10:24, 11:30, she's still talking to Al.
I can already tell that he's going to
48.
have to lay this out
She's
a little
texting
better.
4:36, texting the school saying that her stepfather passed away. Her stepfather who had abused her was not, and you heard it from Dr. Torres at the state hospital, they are not doubting or disputing the abuse that she suffered growing up. And that's from Dr. Torres, who had investigated this, who had medical record provided, who had family members provided, who interviewed other family members, and she says the state hospital is not disputing the horrible trauma that she grew up with. And the person who she had suffered that horrible trauma from, that's who she calls and says dies at 4:36 in the morning. What is more important by this, ladies and gentlemen, important to look at, what is also that we see, what is she not doing? She's not sleeping. She is manic at this point in time. She is texting throughout the night, 2:48, 4:36, 4:36 again, 5:03, 5:49, 7:32. She is up the entire night and not sleeping. There is something going on with her head that is not seeming right. There's stuff going on through the day. The text messages back and forth. Harley leaves for work. Other conversations are going on. And then they leave, they go up to Petco. Ladies and gentlemen, Mr. Young has tried to insinuate that all of this was some type of big preconceived plan, that she had made some decision earlier on at that point in time that she was going to kill Gannon. Ladies and gentlemen, does that make any sense? If she had decided at that point, early in the day, when everybody else leaves, Harley's left for work, she's just there alone with Gannon by herself. If there was a decision that was made that for some reason they cannot explain that she was going to brutally murder him, why is she taking him in the car and going up to Petco to buy Valentine's Day outfits for the dogs? That makes absolutely no sense why she would push back a timeline to just an hour or so before Lena got home, for some reason, unbeknownst to anybody, commit this brutally horrific act. Mr. Young tried to comment a lot about the hydrocodone. Be very careful when they try to put facts in their opinion or what they would like them to be that was not provided by any of the witness testimony. Dr. Ignacio testified that there was hydrocodone in the system. She never made any assertions about how much, whether it was a dangerous level, whether it was inappropriate, whether it would have been affecting him whatsoever that way. All she said is, this was a tox screen, this came back. That's Mr. Young's opinion that somehow this was an overdose of hydrocodone, but there was no evidence of that by their expert. And there is no basis that would be for a brutal, horrible attack on a young 11-year-old boy that she'd just been hiking with up there 24 hours earlier. Something is going on in her mind. Something is there losing it, and something horrible occurs in the basement where there is a brutal attack. The brutality of the attack, ladies and gentlemen, I would say is the strongest evidence in this entire case of a psychotic break. That type of violence wouldn't be needed to kill an 11-year-old boy. Gannon weighed 80, 85 pounds. 11-year-old kid, not the biggest 11-year-old kid, not the strongest 11-year-old kid. Fun, nice kid. What do we know about him? He likes to play a lot of video games, but not needing this type of brutal, horrific rage to kill him. And there is no other, again, explanation other than the psychotic break. Lena then comes home, and ladies and gentlemen, look on that video. Lena wasn't pushed outside. Lena wasn't allowed. Lena came in the house. She's in that house for about 10, 15 minutes. And then she goes out and gets on her bike and leaves. The idea that Lena was never allowed in the house is a fantasy that is not supported by the evidence, that is not supported by any of the videos. Okay, that is Mr. Young's opinion. But look at that video. You see her going into the house. You then see about an hour later, Harley come into the house. And we know that Harley came in the house, and Harley actually went down in the basement. Why do we know that? Because she changes out of her uniform before going to the dollar store. So there is nothing in there that these kids were kept out of this house, and there is nothing to indicate that this was pre-planned that would keep this type of information away from them. What is going on in her head? We don't know. But here's the important thing, and here's what Mr. Young is trying to do. He is trying to introduce antisocial personality disorder into this. Because I would state to you, ladies and gentlemen, there are only two things that account for her actions at this point in time, for the remainder of this day and the days preceding, is either disassociation, where she has put that memory of this brutal attack of what she did to Gannon someplace that she doesn't have access to, and she doesn't understand what's going on or where Gannon is, or what she had done to him, or antisocial personality, or that she's some type of psychopath. Mr. Young, remember back to Dr. Torres, tried to interject many times with Dr. Torres the possibility of antisocial personality disorder, and Dr. Torres was firm. No, she does not meet the criteria for antisocial personality disorder. One, there's no past criminality with her. That's an element that you need for antisocial personality disorder. Other antisocial people with antisocial personality are unempathetic to people. Again, for her entire career, she was a special needs teacher, teaching kids, helping kids who have disabilities. Through her whole life, that had been her career. That is not a psychopath with antisocial personality disorder. That it could be somebody with a dissociative disorder, either DID or borderline personality disorder with dissociative features, who was kept horrible trauma in her past behind her and is trying to make the lives of kids with special needs better for them. That is somebody with empathy who does that whole thing. Ladies and gentlemen, I would put before you the strongest evidence of disassociation going on here. Look at the body-worn camera of the sheriffs when they come in that night looking for Gannon. The most horrible, brutal attack has happened before there. Gannon is in the house in the suitcase. It has all been recently covered up. She's there with her daughter. She's there with Lena. And she is acting and presenting herself to these police, laughing, joking, being incredibly friendly just after this has happened. Because at that point in time, she has disassociated the horrible act that she has committed. There's no other logical explanation for how that she is doing that. And when you go back and look at these timelines, ladies and gentlemen, look and go through them. what is really important during this whole time, she is not sleeping at all. For the whole time here that this is all going on, you see activity going on her phone or things that she's doing all through the night. She is in a manic situation and her mind is not working. Again, we heard Dr. Lewis talk about irrational things that she is doing that doesn't make any sense. Ladies and gentlemen, it makes no sense for somebody who has pre-planned for whatever reason, whatever motive, to brutally kill Gannon, to then report him missing right away, and then in a matter of 3 days later, go into the police with a completely illogical, incoherent story. You've heard different witnesses. Ms. Stauch was an intelligent, above average intelligence woman, a smart woman, everything like that. To go in only 2 days later and sit down with the police and come up with the ridiculous story of Eduardo is not the actions of a sane, rational person. It is irrational belief. Even children know. If you keep saying different stories, you're not going to be believed. Even looking back at the little boy who cried wolf, which we teach children, if you keep making up things, then you're not going to believe. She changes her story, not only completely different, not only with no explanation as to really why she had made up the prior story to one that she is changing now, but comes up with this ridiculous thing that she met this Eduardo, that he was just going to come over and fix the carpet for free. She's not even planning on paying him. That somehow he is in the garage when they get there, that he then takes her down into the basement and rapes her for an hour, and that he takes Gannon in a suitcase and leads out of the home. That are not the actions of somebody who is sane and logical. That is completely irrational to believe that that kind of thing could possibly be believed. Her actions, I would say, continue to be irrational. She keeps changing her story. She keeps giving different accounts. Gannon is placed in the suitcase, driven all the way to Florida. She goes through Louisiana. She goes through all kinds of East Texas, all kinds of places where people are not around, deserted areas, long areas of desolation, many places where that suitcase could have been hidden and never been found. And she goes all the way to Pensacola, Florida, and drops it off in a dry space under a bridge right near a major city. That's not the actions of somebody who is rational, who is trying to hide that away. She then goes to South Carolina, and you can look at the Google searches that she performs in South Carolina. Face transplant near me. Like she's Googling for a McDonald's or a restaurant that's very close to her. This is going to pop up that she's going to go over there and get an entire face plant to change the way she looks. Those are not the actions of a sane and rational person. Those are the actions of somebody that is delusional. Ladies and gentlemen, I would say all of these pretext phone calls with Al are the actions of somebody who is delusional. Listen, go back and listen. Listen to those February 14th phone calls between her and Al. Listen to how her voice and tenor changes between phone calls. Listen to how her emotions switch rapidly during the phone calls with Al, and her stories switch rapidly that no sane, rational person of overintelligence could possibly expect anybody to believe. She is freaking out, and she is delusional in the thought that anybody is going to believe all the different variations that she's trying to sell them. None of that is rational. None of that makes sense. And so again, what then we're brought back to is why. What was going on? What preceded this? And looking, it's going to end up in the mental health experts. And I want to talk a little bit about Dr. Lewis. She is 85 years old. She has been doing research, treating, evaluating people with serious mental illness for over 60 years. She is one of the foremost experts in the country on dissociative identity disorder. She has been published in peer-reviewed journals well over 100 times. Things that educates other interests and things that educates other doctors, she has authored and produced. She has done, she has the HBO documentary. They don't go just to quacks to do an HBO documentary. They went and they did a documentary on her because she was groundbreaking in her field. Has she consulted on other stuff with Robert De Niro and so forth? Yes. Not because she's a quack, because she has explored and she knows more about this subject than almost anybody else in the country. Has she, in her age, some of the details, the minute things in the discovery get lost a little bit in her memory? They do. And you saw that up on the stand when she was testifying. I'm not disputing that. But what she has is the decades and decades of experience with this, the decades and decades of dealing with people with severe mental illness who commit heinous acts. She has that experience to rely upon, and she had 14 hours of interviews with Ms. Stauch to talk with her, to base her opinion. She had notes from family members, other types of things to show this. And in her expert opinion, is legally insane. She wanted the EEG and the MRI to possibly know if there was also organic brain damage going on here. There was some type of brain trauma that was contributing to the mental illness of Ms. Stauch. But what you heard at the end is she did not need those type of things to make the diagnosis of dissociative identity disorder, which she was confident on and she believes upon. Ladies and gentlemen, I would ask you, do not discount her decades of experience. Do not discount her expertise, okay? They acting that, this is a woman who has pioneered this, a woman who has made her life on this, a woman who has been peer reviewed over hundreds of times in different articles on this subject, is willing to throw that all away to come down here at a substantially reduced fee to testify is ludicrous and it's insulting. They pay their experts just the same as we do, okay? Then that's why I asked their blood spatter expert, his fees. It wasn't acting like there was anything wrong with that. It's just to show both sides hire experts, both sides pay experts. Just because the expert isn't getting paid doesn't mean that they are money grubbing liars, okay? Experts in this type of thing, to come and testify, they charge money, they charge a fee. She actually reduced her normal fee to come down and to help with Ms. Stauch and to do this evaluation. And what did she tell you, ladies and gentlemen? Ms. Stauch, of all the hundreds and hundreds of different mentally ill people that she has ever dealt with, is one of the most mentally ill persons that she's ever dealt with. And what else is she saying? I think this is key. Pay very close attention. She's not endorsing that it was definitely Maria that did this. She's not endorsing how Maria is saying this happened. What is she saying? Ms. Stauch has, in her opinion, more than likely disassociated the memory of the homicide because she can't bear to deal with it. That was actually a very good question by Mr. Young on it. And I think there's a lot of validity to that. Ms. Stauch accepting the idea that she committed this brutal, horrible homicide in the manner that was done, smashing that 11-year-old's head in, cannot deal with it. To accept that fact in her mind would crush her, would crush her soul, would crush her identity. And so she has come up with all of these delusional fantasies, trying to come up with some other thing that may have happened. And listen to her voice, listen to the tenor when she's describing that. When she's hoping, when she's talking to Dr. Lewis, I can't remember if it's Dr. Lewis or Dr. Torres, about the different versions she's given, that she was coming up into her mind, hoping and believing it was somebody other than her who did this. The facts, ladies, and we're not disputing that, ladies and gentlemen, it was her. But she was not in her right mind when she did it. And you heard Dr. Lewis state that. And you can look at the evidence and you can look at the other things that go around to realize that is the only reasonable, rational conclusion as to how this horrible thing happened was a psychotic break. Was a psychotic break. Dakota Lowry, who when he finally realized that his older half-sister actually did this, the first thing that came into his mind, based upon what he knew of his half-sister, was there had to be some type of psychotic break that had happened. That there could be no other explanation as to why it did it, and those are people that knew her and that have grown up with her. I also want to talk a lot, or some, about Dr. Torres. And it is what is important, ladies and gentlemen, to know with both Dr. Torres, Dr. Gray, and Dr. Grimmett is none of the experts that you have heard from that did any type of evaluation think that there's no mental illness going on here. Okay, they all agree there's some type of mental illness. They just disagree over what to call that mental illness. We have Grimmett and Torres and Gray diagnosing her with borderline personality disorder, which is a significant mental illness, which, as you said, comes from right on the border between full-blown psychosis and a neurosis. Okay, it's the most serious of all the personality disorder, and it's so serious because there are such prominent features of psychosis that go along with it. Psychosis where people hallucinate, psychosis where people become delusional, psychosis where people stop becoming irrational. All of that stuff can come and go in people with borderline personality disorder. And it comes and goes according to DSM-5, according to Dr. Torres, according to Dr. Grimmett, when people with borderline personality disorder start to experience high stress. That is why Dr. Niederhauser was important. It was not because Dr. Niederhauser made any type of diagnosis or anything with that, but she came to Dr. Niederhauser because he was experiencing high stress and high anxiety that was causing her be unable to perform at work. The stress and all of that was mounting. You can look at her Google searches. The Google searches leading up to this. For whatever reason, her stress in life was becoming overwhelming. She felt underappreciated. She felt like running away. She felt like leaving. She felt like this was all too much on her plate, that there was nobody there to help her. And you heard from Dr. Torres about how people with borderline personality disorder feel stress much different than everybody else. Things that would not be normal stressors for all of us can become extremely stressful for somebody with borderline personality disorder. And the other thing that was important that Dr. Torres, we talked about quite a bit, is it is a lot of the same things, the same type of horrible childhood trauma, the type of trauma where you have one parent who is molesting you and another parent who won't do a damn thing about it, that can cause either dissociative identity disorder or borderline personality disorder. They both come from the exact same of environment that Dr. Torres said Ms. Stauch grew up in. That type of environment is what can cause people to have borderline personality disorder, which then under periods of stress and anxiety can become psychotic. And I think one of the other things, and I think is something to look in, and something I want you guys to think about when you go back in that jury room, is something that Dakota Lowry said at the end. We don't know exactly all the intricacies of the trauma, of the abuse that Ms. Stauch suffered. We don't. Some of that she knows about, some of that she's come to remember, some of that is locked away, some of that is hidden by other family members who don't want to admit it. But what did Dakota talk about when he was a kid and after his stepdad has died and his mom had moved on to another abusive alcoholic in the home, and Ms. Stauch would come visit him? What would she do? She would leave him with knives to protect himself from something or someone. And the fact you can draw that Ms. Stauch sometimes as a kid going through that trauma either had to protect herself with some knives or fantasized about having a knife to protect her. And then you have the connection between Gannon being stabbed 18 times with a knife. Some of these things are hidden. Some of these things are hard to look at, but there is that association there between what we can assume was some of the childhood trauma that Miss Stauch suffered, how she dealt with it, and how this horrible thing happened to Gannon. And I understand that Dr. Torres didn't think she was insane, but you can't discount the fact that Dr. Torres readily admitted borderline personality disorder can be a serious mental illness. People with borderline personality disorder can suffer psychosis. People with borderline personality can become irrational. People with borderline personality disorder can disassociate things that the whole person cannot deal with. And that disassociation explains all of these crazy cockamamie lies. It is a fantasy on Miss Stauch to try to explain this horrible action that she cannot rectify in her home with. And whether you call it borderline, whether you call it DID, I think Dr. Lewis was correct. That is not necessarily the important thing. What the important thing is look at the facts overall and realize this must have been some type of psychotic action going on, because normal people, mentally healthy normal people, don't one day go on a hike, take smiling photos, and the next day stab a kid 18 times for no apparent reason. And no matter how much Mr. Young would like her to be antisocial personality disorder, and he would like that because that takes insanity off the table, none of the evaluators ever have diagnosed her with antisocial personality disorder. None of the diagnoses ever have even had the rule out antisocial personality disorder. Antisocial personality personality disorder is something that is always considered at the state hospital, but there are criteria, and she did not meet it. No matter how many times in different ways Mr. Young tried to act, asked Dr. Torres about it, she was firm and said, no, that is not the diagnosis that we have given her. That's not the diagnosis that Dr. Gray gave her. It's not the diagnosis that Dr. Grimmick gave her, and it's really not the diagnosis that Dr. Lewis gave her. So all the antisocial personality disorder talk is a smokescreen. And when you take the antisocial personality this off, the only thing that explains her conduct afterwards is disassociation, is disassociating from the horrible thing that she has done, and she's trying somehow to fix this or to get out of it. The other thing that I want to talk to you, and it's important, that was very apparent with Dr. Torres, Mr. Young would like you to believe that the only time somebody is legal insane if they commit the crime and they just stay there saying, yep, it was me, I did it for these reasons. Dr. Torres and the jury instructions from the court state somebody cannot know right from wrong, but still recognize that their conduct was criminal when it occurred. And so you heard from Dr. Torres, just because somebody in a state of psychosis, in a state of insanity, commits a horrible murder and then tries to cover it up, the covering up of the murder does not preclude insanity. And she talked about how there are cases that she has had where somebody was insane who then tried to cover up the acts that they have done because they didn't want to suffer the criminal repercussions. They are not mutually exclusive. That's not coming from me. That's coming from the instructions that you have from the court. Ladies and gentlemen, you guys have been above and beyond in this. And we are very grateful for the time that you guys have given us, the thought that you guys have put all into this, the sacrifice through this long trial. I'm not going to rehash every detail on here. You guys know it. You guys understand it. You guys have heard the experts. You guys can put all this stuff in there together. We are asking you to find her not guilty by reason of insanity. We're not saying set her free. We're not saying let her go. We're not saying don't hold her responsible. We're saying for you to take into account the mental illness that she suffered and send her down to CMHIP, where you see how it is down at CMHIP during those interviews with Dr. Torres, where she's shackled fully, where there's constraints, where it's a locked facility, and that's where Dr. Torres told you if you find her not guilty by reason of insanity, that's where she is going, where there is repercussions, but there is also treatment for the mental illness that she has suffered from her entire life. The other thing that is important, I just want you guys to remember, is the burden of proof. It's not whether you decide, oh, I think that she was psychotic at the time, is have they presented enough evidence before you that you can say, without a doubt, there is no way psychosis was involved here. Have they completely disregarded that? Have they completely wiped it out? And I, ladies and gentlemen, I would put before you with all the different doctors diagnosing with some serious mental health illness, with their witnesses they called diagnosing with a mental illness that has transient periods of psychosis, when psychosis appearing to be the only rational explanation, with no other motive for this horrible thing, with the overkill that was involved here, with the irrational behavior afterwards, even up and through some of these interviews, even up through some of the trial, all of that points to mental illness. And in no way, shape, or form have they disproven that. And it is their burden. And so if you believe that it is possible that this occurred in a state of psychosis, your legal duty, which you have sworn to do, is to find her not guilty by reason of insanity. And that is what we are asking you to do. Thank you.
Council approach, please.
Well, he certainly came out swinging there at the end. That's going to give people something to talk about, think about, for sure. Deanna said it is me. Yeah, he's making me.
All right, ladies and gentlemen, the prosecution does have a right to a rebuttal, and they are going to exercise that right. But you've been sitting there for a while, so what we're going to do is take about a little bit more than a 10-minute recess, give everybody some time to stretch, use the bathroom, those sorts of things. So if I can have everyone back in the jury room at, say, 10 after 12, we should be able to start on them at that point. Again, don't discuss the case among yourselves, don't discuss the case with anyone else, and we'll see you at 10 after 12. All rise for the jury, please.
Well, did you guys get all of that? Do you want to recap? Let me know what you want. I've got about a 10-minute break. I do think her defense did a good job towards the end. I'm definitely glad that it was.
The record should reflect the jury has left the courtroom.
That it was this attorney and not Loverboy over there.
We just turn the screen back to.
Yes, absolutely.
All rise.
If you want to be a
She looks pretty confident. You catch that? She looked pretty confident to me. Yeah, Loverboy. All right, let me see if I type just about as fast as they talk, but sometimes the way they talk doesn't make any damn sense. So let me see if I can, for the next 10 minutes, kind of go back over what they've said. So they started with the prosecution, and these probably are not complete sentences, but I'll do my best. He said no evidence of psychosis in the evaluations. She exaggerates to a point where even people that are hospitalized for mental illness don't answer questions the way she has. Her second competency evaluation with Dr. Grimmett, Leticia starts talking about bipolar disorder and personality disorder. That's when she says she has 4 personalities. But at that time, none of those were Maria, which is strange because Maria is like her star personality, right? Dr. Grimmett said Leticia was making these names up. She also talked about vampires and cited characters from the movie Twilight. Dr. Grimmett was like, these are characters from a movie, not dissociative identity disorder. So Dr. Grimmett did not diagnose her with DID, but did say she had borderline and narcissistic features. he said something about Dr. Lewis testifying that I'm guessing she must have told the defense team or Leticia that she recommended she plead not guilty by reason of sanity, and if so, she would do the evaluation. They said insanity requires you to go back to the time of the crime to evaluate. So not before, not after. Dr. Torres and Dr. Gray attempted to talk to Harley and other family members, but Leticia had now created more personalities to her did. There was 2 interviews done in March, and one in March, one in June. In March, Leticia mostly talked. But in June, Dr. Torres asked to talk to Maria, and Leticia said no. Maria doesn't just come out. There has to be a triggering event. Can't just summon her. Said there was no severe abnormal conditions that impair her perception of reality, no psychosis, and no bipolar. They also said no did. They continued on with diagnosis of the other 2 disorders. Dr. Torres and Dr. Gray came to the conclusion that Leticia was not legally insane at the time of the crime. He then went on to talk about the motives of Dr. Lewis on testifying, and he said money is a strong motivator. Having shows on HBO, her son videotaping interviews on a high publicity case for possibly another documentary equals motive. He said she didn't answer any questions asked by the prosecutor because she didn't want you to know the answers. And then he said, talk about narcissistic tendencies. Eek. He said, this is the expert that the defense chose to come in to do a neutral evaluation to get the truth. She didn't even know the legal definition of insanity in the state of Colorado. The whole reason that she came to testify. That I'm not even sure what her opinion is anymore. Remember how she answered your questions at the end? She said, my opinion is ongoing. So what does that mean? Does that mean that her opinion counts for anything? Because when you think about her insanity report, she says she needs an EEG and MRI done. But that doesn't happen. He then went through kind of the timeline. Quite a bit of that timeline. I don't think we really need to go back over it. The one thing I did catch that I had not heard before is that when she was arrested on March 2nd, 2020, she says it's Angel, the babysitter, that did it. But meanwhile, she has a suitcase with Gannon's blood on it that was found on her at the time of her arrest. I did catch that, Deanna, and he was saying her and Harley, but I don't think he was implying that Harley had anything to do with it. He also used the word they another time, but he was referring to Gannon's body and Leticia. All right, they've got about 5 more minutes. He said, the prosecutor, that is, said that people that are truly legally insane under these circumstances don't act like that. That's what we've all been saying. If they don't have the capacity to know right from wrong, they aren't going to hide the body. They may even do the crime while someone was watching. Do you think she would have done this to Gannon if anyone was in the room with her? Hell no. Hell no, she wouldn't have. They don't lie because they don't see what they did was that wrong. It's like a little child, you know, when they do, you know, things that we know they're not supposed to, but they're little and they haven't yet learned right from wrong. They don't really try to hide it, do they? Because they don't know to lie about it. He said they don't lie because they don't see what they did was wrong. They may say things like, the devil made me do this. I had no choice. And he said that's what we're talking about in capacity and intent. And the only correct verdict is guilty. And then the defense came up and said the one thing they can't answer is motive. She was loving and kind at Garden of Gods to less than brutal rage less than 24 hours later. This wasn't pre-planned, calculating killing. It was a psychotic rage attacking a demon from the past. So that is their defense. He said there's no motive that makes sense. They've interviewed everyone and have come up with no motive. Now, he's saying the prosecution has no motive. Nobody they have interviewed have ever said she was mean to Gannon until that horrible day. That's the evidence and the strongest evidence to know it wasn't premeditated. It was a psychotic break, and the only thing that makes sense. Said there is no rational explanation. She was a special needs elementary teacher, a mother to Harley that did everything possible for her. She tried to be the best stepmother, the best wife, so much so that she was left with them for long periods of time in her care. And Al felt comfortable with what he had seen regarding her relationship with his kids. Said mental illness from her past was triggered and she had temporary psychosis. There's nothing else they can come up with for motive. Does it make sense she Googled moving to Florida? Yes. But how does brutally murdering Gannon facilitate that move? It doesn't. He said a year before, she may have done one search out of thousands saying she doesn't like her stepson. That's not what you see in that picture of him and her. And they're talking about the picture at Garden of Gods. Her attorney said, what do you see by looking at the evidence in front of us? Is that somehow that fire set off some type of trigger that had been disassociated a long time ago. But she starts melting down right after the fire. When something doesn't make sense, we have to consider it mental illness and possibly psychosis. He says he didn't go into much of the timeline. Thankfully, the prosecutor did, and I think we all know it really well by now. But he did say at 10:15 p.m. the night before, Harley comes up. She got home from work. At 11:30, Leticia's still talking to Al. 4:36 a.m., she texts the school that her stepfather had passed away, a person that she herself had suffered horrible trauma from. The attorney said what's more important to look at is she's not sleeping. She's like manic at this point. She's texting throughout the night. So there's something going on with her head that doesn't seem right. The next day, she goes to Petco. And he said Mr. Young has tried to insinuate that this was a preconceived plan, that she was going to kill Gannon. But does that make any sense? If she was going to brutally murder him, why was she going to Petco to buy Valentine's Day outfits for the dog? Just an hour or so before Lena got home. Mr. Young commented about the hydrocodone. Her attorney said to be careful, that the doctor testified that it was in his system, but not how much or if it was even a dangerous level. He said that's Mr. Young's opinion. There's no evidence of this by their expert. They did not say how much hydrocodone was in his system, but they did say it was more than what they would expect for a young child. Then he said the brutality of the attack is the strongest evidence of a psychotic break. That type of violence wouldn't be needed to kill an 11-year-old boy, especially a smaller built one. He said Lana then comes home. She wasn't pushed outside. She was actually inside the house for 10 to 15 minutes and then goes and gets on her bike. And about an hour later, Harley comes home and she goes down in the basement to change. So he's saying Leticia wasn't trying to keep the kids out of the house or to hide any kind of evidence from them. He did say what's going on in her head, we don't know. But Mr. Young is trying to introduce antisocial personality disorder into this. But only two things account for her actions. Either disassociation or antisocial personality disorder, like that she's like some kind of psychopath. Dr. Torres said she doesn't meet the criteria for antisocial personality disorder. And then he goes on to say she was trying to make life better for special needs kids, which shows she has empathy. She had to go to a counselor to get a medical thing so that she didn't have to be a teacher anymore. Come on. Then he goes on to say, look at the body-worn camera of the sheriffs that come in that night looking for Gannon. A horrible, brutal attack. Yet Gannon is in the house in a suitcase. Here she is with Lana and Harley. She's laughing, joking, being friendly, because at that point in time, she's already dissociated from the horrible act she's committed. And he said there's no other logical explanation. When you go back and you look at the timelines and you go through them, what's really important is not sleeping at all. Did you see activity on her phone? etc. She's in a manic situation and her mind isn't working. We heard Dr. Lewis talk about irrational things that she's doing that make no sense. He said it makes no sense for someone who has pre-planned killing him to report him missing right away. 2 days later, going to the police with a completely illogical story. Well, lots of parents that have killed their children report them missing, some even like immediately. So that's kind of out the door. He said Miss Stauch is above average intelligence. To come up with the ridiculous story of Eduardo is not the actions of a sane and rational person. Even children know that if you keep telling different stories, you're going to not be believed.
Thank you.
The most important thing he said was jury instructions state someone can realize their acts were wrong during psychosis, but the covering up of the murder doesn't preclude insanity because they don't want to suffer the consequences. They're not mutually conclusive. So she could have been psychotic during that time, but afterwards, like snaps out of psychosis, realizes what she's done, and she's going to try to cover it all up because she doesn't want to face the consequences because Leticia's back now, right? She doesn't want to face those. He said the burden of proof is not whether you decide you think she was psychotic at the time.
All rise for the
It's
jury,
did the
please.
prosecution present
I
enough evidence
Or hear anything, so.
Oh, all
that
right.
you can say there's no way psychosis was at play here. And he said all the evidence points to mental illness, and the prosecution has not disproven that. Hopefully that helped a little bit if you missed anything, and they are back. Absolutely, Deanna. If you guys haven't, please give the video a quick like while we're waiting. I'd appreciate that. It helps my channel a lot. Somebody needs to chuck his phone. He's like grinning.
All rise for the jury, please.
Yeah, Peacock, you're right about that. Harley's always been expected to behave at all times. She definitely testified that she didn't go against her mom. I don't remember her
Thank you.
exact
May all be
words.
seated.
She made it clear she
Court
didn't.
will recall 20
She
CR
very rarely would
1358
go
People
against her
versus
mother.
Letecia Stauch. Record should reflect the jury has returned to the courtroom. At this time, ladies and gentlemen, we will start into the prosecution's rebuttal. Mr. Allen.
Thank you, Your Honor. Ladies and gentlemen, the only fantasy in this courtroom is that this defendant, this stepmother who killed Gannon, had a psychosis, that she was insane on January 27th of 2020. That is the only fantasy that has been brought out into this courtroom. It's been brought out by this defendant. They want to talk to you about motive. We talked to some of you in jury selection about motive. One thing you didn't hear the judge read in any of those instructions is anything about motive. You know why? It's not an element of a single crime under Colorado code. We don't have to prove motive, and yet we did anyway. This defendant hated Gannon. You know that because she searched it. I hate my stepson. She has one stepson, and she hated him. She was planning to leave Al Stauch, move back to the East Coast. She wanted to hurt Al. She wanted to hurt Landon, for that matter. She did, to the core. They will never recover from what she did to them, ever. And you know that. Think about the time frame that we're talking about. This was no snap in time. Look at the searches that we talked about on Monday when Kevin Clark took the stand. We know when she was looking to leave. We know she hated Gannon. She knows she wanted out of a marriage with Al. We know that she didn't like what Landon was up to because she would manipulate Gannon about Landon. We We know these things because of the evidence that we brought you. And in fact, it does prove motive. I want to ask you about, why did Al leave Gannon with the defendant on that weekend? He left on January 25th, Saturday. Remember that? Why would he leave and go to Oklahoma for 2 weeks of training if he knew there was a problem with the defendant? From psychosis. Al told you the answer to that question. He would not have gone. If he had seen some problem with the defendant, he said he would not have gone. And he did anyway, because she doesn't have psychosis. He never saw a single sign from her. What he didn't know, unfortunately, he couldn't see into her heart. He couldn't see the hatred that she had for Gannon, the motive that she had to leave and to hurt him to the core. He didn't know that it was all about her, even though he'd lived with her for some number of years. Defense wants you to speculate that the fire set off some sort of a trigger. You read those instructions while the judge was reading them to you. It says speculation, can't do it. And yet they're inviting you to speculate. Why is that? Why would they invite you to speculate when we're talking about an 11-year-old boy who was brutally murdered? Why would they invite you to speculate? Because they want you to ignore the evidence that was brought into this courtroom. They want you to ignore this evidence and speculate on the other hand. You can't do it. Saying she's freaked out in that phone call. Acting she's freaked out. We all get freaked out sometimes. As Mr. Young said, we're human. Go drive down the highway and you see an accident, you might freak out, you might have some rush of adrenaline, and it kind of messes you up a little bit. That's human, not psychosis. And further, that freaking out that she's supposedly doing is her acting. It's not psychosis. It's all about Leticia. It's all about this woman who murdered Gannon throughout the whole thing. The text to the school, to Leslie Hicks, that morning, January 27th. I want you to speculate again that that's some sort of a trigger. You know what it is. It's an unassailable excuse. You tell your employer that your stepfather, a member of your family, has just died in a tragic car accident. No employer is going to make you come into work that day. She needed an unassailable excuse to not go to work because she knew what was happening later that day. He knew Gannon was done that day. That's why she calls Gannon into school later, or out of school later. The timelines that we brought to you on Monday, her internet searches tell you everything you need to know about her mental condition. She was calculating, manipulating, lying to everyone. Why? Because it's about her, not about Gannon. Deflect the blame and make herself the victim. Does it ever make sense when somebody kills another person? Can it ever truly make sense? Can it ever truly make sense when a parent kills a child? The answer to that is no. None of us in this courtroom, except one, has killed a child. That doesn't make it a psychotic act. That doesn't mean somebody's insane. Unfortunately, way too many people kill kids in this country. Why do they do it? Who knows? But it's not psychosis when this one did it. Be very careful when people introduce facts. Mr. Tellini got up here and wanted to introduce facts to you. Inviting you to speculate. Be very careful about that. He tries to brush away the effect of the hydrocodone that was found in Gannon's system. First of all, Gannon should not have had hydrocodone in his system. Dr. Ignacio told you about that. It's not typically given to 11-year-old little boys. Why not? It's an opioid. It can cause people to get sluggish, lethargic, and lead to coma, and stop you from breathing, and can kill you. All of those things that hydrocodone, an opioid, can do to you, this woman did to Gannon. Why? Because she wanted to kill him. Mr. Tellini brought up the idea that the brutality itself proves psychosis. Is that true? Does the brutality itself prove psychosis from this defendant? The evidence has the answer for you. The defendant's own actions has the answer for you. The brutality of it speaks to the abject hatred she had for Gannon and the pure determination she had to kill Gannon. This didn't start in one snap moment. When did this start? Sunday night. Sunday night with the candle. A candle incident that makes no sense, according to the way that she describes it to people, because she wants to make it Gannon's fault. Does that make sense? Mr. Stauch told you the answer to that question. Harley told you the answer to that question. Gannon didn't play with fire. He would never go downstairs and just light candles randomly. He had a long history of having stomach issues, where he'd get backed up and then have issues with it. And yet this day, he poops himself, and so he's got to go burn a candle to mask the smell, even though he'd never done it any other time in his entire life. Does that make sense? Or does it make more sense that this defendant burnt him? That's the start of the attack, ladies and gentlemen. Sunday night. And it continues with the hydrocodone, a prescription for a full-grown man, is given to Gannon. That goes into the morning time. That's why he's lethargic. He can't get out of bed early like he normally would. He's walking slowly to the pickup truck at about 10:15 in the morning when they leave the house, because he's under the influence of hydrocodone. And then she drives him around, leaving him in the car. He's probably passed out in the car. Doesn't make any sense to leave an 11-year-old boy in a car unless there's something wrong, something that she did to him. And this picture from Garden of the Gods, these two pictures that she sends Al Stauch that morning of Gannon in bed. Mr. Tellini again is inviting you to speculate as to the reason for those pictures, saying she's just a loving stepmother. What are those pictures? Think about that picture from Garden of the Gods in relation to the pictures that she sends Al Stauch. They're proof of life pictures. They're pictures that she is sending out, prove to the world that she had nothing to do with what she's about to do. Why would she send pictures of Gannon in bed to Al Stauch, except for a proof of life picture? A way to cover her tracks, and it starts early, right? They want you to think that this was some sort of a temporary snap. Said it on opening statements when Mr. Cook dramatically walks out of the courtroom, says this is way too worse, we can't handle this. It's a crack in her psychosis. And then we hear it again today from Mr. Tellini. First of all, temporary insanity is not what our insanity statute is in the state of Colorado. Look at it. That does not apply here. Second of all, there's not a temporary insanity moment in this case. It starts from Sunday night and goes all the way through Monday evening. Talking about almost 24 hours of horror that Gannon had to suffer at the hands of this defendant. what should have been the safest place in the world for Gannon to be. People who live by stories, by telling tall tales, don't stop. Why would she stop doing that once this case started, if she'd been getting away with it her entire life? Think about the manipulation that she carried out on everybody else in her life. Al told you about the manipulation. Everything this woman did in her life was manipulation to cause chaos, to make her the victim and the focus of everything. Every single thing. Harley. She didn't know how her own father died. Because she was lied to by this defendant. Why would she stop lying when the biggest thing that she's ever caused in her life is being drilled into by an investigation that is the biggest El Paso County has ever seen? That involves the FBI. That's who she is. She's a storyteller. Telling fantastic stories is not psychosis. It's who she is. She starts looking up face plant surgery centers. She starts looking up, I need a new social security number. I need a marriage license. I need a replacement passport because El Paso County Sheriff's Office has mine. And she looks up fake polygraph. Why in the world would you need a fake polygraph unless you're covering your tracks? To have some sort of thing that you can anchor a legitimate story to that you didn't have anything to do with this case. Why? Who thinks of that stuff except for people like this? I would venture to guess that not a single one of us in this room ever even knew a fake polygraph website existed before now. I know I didn't. Let's talk a little bit about Dr. Lewis. She might be a world-renowned expert. She's the only expert that they could find to bring in here to tell you that this defendant had dissociative identity disorder. Not a single other doctor that testified here in this courtroom saw a single shred of evidence that she had dissociative identity disorder. Not a single one. And yet this doctor comes in and says she does have it. This doctor comes in and says she does have it, and yet she doesn't even know what the definition of insanity in Colorado is. She starts throwing around words like McNaughton and other things that might apply in other states. And she said sanity could depend on where you are, what state you're in, that kind of thing. Don't you think if she's going to come in and tell you as an expert, this defendant is insane, according to Colorado law, should know what Colorado law is, and she couldn't do it? There were a lot of I assumes, I don't knows, deflections, stories about other cases. Anytime she was pressed to justify her opinion, she couldn't do it. You saw Dr. Torres in contrast to that. She could point to specific things about her evaluation of the defendant. Compare the two. The instructions that you got from the judge are your roadmap for this case. They help you determine what the law is, and you're expected to follow the law, and you apply that law to the facts in the case, to the evidence that's been piling up over the last several weeks. The presumption of innocence absolutely applies in every single criminal case. It applies in this case. Until you are determined that the charges have been proven beyond a reasonable doubt, she has the presumption of innocence. We have the burden of proof. This system doesn't work if you don't hold us to our burden of proof. We expect you to hold us to our burden of proof. We welcome you to hold us to our burden of proof. Mr. Tellini talked about proving it without a doubt. Proving this case without a doubt. You'll never see words like that in any jury instruction in the state of Colorado or in the United States. You don't have to prove cases beyond all doubt. You have to prove things beyond a reasonable doubt. Because this is, after all, a human function. Nobody can ever prove anything 100%. Johnny Cochran, after the O.J. Simpson, or during in closing for the O.J. Simpson case.
Your Honor, I'm going to object to the reference of Johnny Cochran and O.J. Simpson.
There's no evidence of it. It's not commenting on evidence.
I'm sorry?
It's not commenting on it. There's no evidence of what Johnny Cochran did at any point in time. So,
I'm actually using it to talk about the burden of proof, Judge.
well, then rephrase it.
Well, I was about to. So in that case, Johnny Cochran said, if it doesn't fit, you must acquit. What he's talking about is our burden of proof. And he was absolutely right. If a case is not proven beyond a reasonable doubt, your jobs as jurors, according to these jury instructions, is to find a defendant not guilty. And we expect you to do that. If we didn't prove the case, then hold us accountable and find her not guilty. But if we did prove the case beyond a reasonable doubt, the jury instructions are also very clear on that. We have proven the case beyond a reasonable doubt. The jury instructions tell you you should find her guilty. If the crimes fit, you should convict. That's what the jury instructions say. And that's the other side of the coin from Johnny Cochran's comment. If the crimes fit this defendant, convict her. Deliberations are up to you. When you get back into the deliberation room, you get to control how that deliberation goes. The only requirements are that you all have to be together when deliberations are happening. You have to do it in the jury room. But you can take as long as you want, and you can be as fast as you want to come to a conviction or to a decision. Nobody's ever going to second guess you. If you take 2 weeks or 10 minutes, it's up to you. What we do know, what you should know from the evidence, that there's plenty of evidence to find this defendant guilty based on the evidence, not from what I say or what Mr. Young says, or find her not guilty because Mr. Tellini and Mr. Cook say so. The evidence guides you. Let's talk about that question of sanity. It says, so diseased or defective in mind to be incapable of distinguishing right from wrong. Can this defendant distinguish right from wrong? The evidence and her actions tell you that she can. Why do all the things she did if she didn't know what she had done was wrong? Or she suffered from a condition of mind caused by mental disease or defect that prevented her from forming a culpable mental state. What is evidence of that culpable mental state? As Mr. Young said, it's in Gannon. It's on Gannon's body. The evidence that Gannon's body provides you, the story that tells about what she did, shows she has the ability and had the ability to form the appropriate culpable mental state. You don't stab an 11-year-old 18 times, 11 of which are on his arms and hands as he's defending himself, unless you intend to kill him. You don't then dispose of that knife that's never recovered and hit him over the head with such viciousness 4 separate times that it cracks his skull open, unless you intend to kill him. And that blunt force object, also never found. And then you don't retrieve a handgun, a 9mm handgun, and squeeze that trigger 3 intentional times. Again, in one time. That's exactly what this defendant did. And that's how you know she could form the appropriate culpable mental state. This woman doesn't have a diseased mind. She has no psychosis. Multiple doctors and longtime family friends and family members answered the question of psychosis for you. This defendant knew then and knows today the difference between right and wrong. Harley said it. Dakota Lowry said it. Al Stauch said it. Every single person that knew her knew she knew the difference between right and wrong. She was of sound mind, informed the culpable mental states required. You learned about dissociative identity disorder from at least 2 different doctors in this case. Extremely rare. Prevalence in society is roughly 1.4%. But most importantly, it's marked by severe behavioral health symptoms that would be noticeable by others. Other people like Harley Hunt, her daughter who lived with her every day of her life. Al Stauch, who was married to her for 5 years. Dakota Lowry, who was her younger brother. These people would have noticed that she had something wrong with her. The forensic nurse examiner, Amanda Van Nest at the hospital, would have noticed it. This is 2 days after Gannon is murdered, and the defendant fakes that panic attack in the sheriff's office and is taken to the hospital, given the opportunity to be examined for the supposed rape story that she had. And she splits. Amanda Van Nest told you that she's dealt with people with severe mental health disorders. She's told you what happens when she deals with people like that. Called an M1 hold. It's an emergency situation where you put somebody in care for a period of time because they're a danger to themselves or to others. Amanda Van Nest saw no sign that this defendant was anywhere close to justifying an M1 hold on January 29th. Dr. Niederhauser, on the other side of this equation, about a month before Gannon was killed, the last medical professional to see the defendant before Gannon was killed, also familiar with M1 holds, and saw no signs that would justify holding her against her will because she was a danger danger to herself or others, because she wasn't. She didn't have psychosis. Why blame others? First, it's Gannon's fault, right? He pooped all over himself, started a fire. He's experimenting with drugs. Isn't that convenient that he's experimenting with drugs? He's curious about bath salts. And there's a Swisher Sweet planted in his backpack. And he's got hydrocodone in his system. Isn't that convenient? Isn't that convenient concoction from this defendant? Then she says he went to a friend's house and didn't come home. Or is it because he loved his mom too much? He was a mama's boy. Is that the source of her hatred for Gannon? She knew she could never replace the love that Gannon had for Landon. And she concocts Eduardo, some random Mexican guy that works at the housing development. Just gives him access to the house through the garage code. He comes in, fixes the carpet, but in addition to fixing the carpet, he rapes her. Bangs her head on the floor, no sign of injury on her. Curiously asked for boxes in a suitcase. Why'd she have to introduce the suitcase? Had to explain away why Gannon was going to be found in the suitcase she put him in. A suitcase that Al Stauch recognized when he was shown the picture. A suitcase that Dakota Lowry recognized this defendant struggling with before she drives off to Florida. We had to explain it away. Next, it's Quincy Brown's fault. You heard Special Agent Jonathan Grusing. He talked about he wishes he would have pushed her more on the Quincy Brown and let her expand on that character. Because this is the character she gave the most information about. It's a real guy. Guy that was published in the media. The most wanted people in El Paso County for sex offenses. Perfect fall guy for what this woman did. He replaces Eduardo as the rapist. Knew his name when his ID fell out conveniently and landed on the floor in front of her. Then he turns into a guy up in northern El Paso County selling a bike. Or he's laying in the road as they're driving and gets into the car and forces them to come back home and he rapes her there. Or Gannon's test riding a bike, crashes, hits his head, and then he takes off with Gannon. Uncle Matt, the least descriptive person in any story this defendant has probably ever told. Boy, can she tell some stories, can't she? Somehow Gannon knew him and he was involved, but we don't really know how. And then it's the pregnant lady with the cash baby. Supposedly 8 months pregnant, involved with money laundering for Mexican restaurants, gets into the car, starts pulling money out of her belly. Somehow she's involved with what happened again. She's pointing outward, right? Pointing anyway except for her. Except that in each one of these stories, the blame for Gannon's disappearance is someone else, and she's the victim in every single one of these stories. Figuring out a way to cast blame elsewhere and situate herself as the victim as to what happened. That's a very calculated move. Every single time she does it, she's doing it to explain away why pieces of evidence are found in the case. She knows about the suitcase is going to be found. She notices that we're searching up in northern El Paso, southern Douglas County, where the board is found. So that's when the bike story comes in with Quincy Brown up in that area. She's got to explain away why her GPS is going to show her up in that area. Just up there innocently looking for a bike. But Gannon's blood is going to be found up there. Got to explain it away. Landon's fault. This is the most cruel of all, right? That somehow Landon is responsible for a Gannon because of her ex-husband. That somehow Landon is involved with Gannon ending up in Mexico. Why would she introduce the word Mexico? Because by the time she's saying this, she's already pitched Gannon over that bridge in Florida, thinking it's pitched over into the Escambia River that flows out the bay and into the Gulf of Mexico. It's Al's fault. His fault that Gannon is gone and he should be investigated. Somehow he contaminated the scene. Another cruel twist of the knife. Going after the people that Gannon loved the most and who loved him the most. Shows you the hatred that she had for these people. The hatred that she had for Gannon and how she's going to use Gannon's horrific demise against the people that loved him the most. Her stepfather, James, supposedly sexually assaulted her as a kid. It's his fault that she's the way she is. Except there's not a shred of evidence from anybody until she starts raising competency that she ever suffered any sort of ill harm by James. She never reports it to a single person for over 20 years. And yet that's the trigger. Does that make sense? There's a caped invader's fault. It's the last one, right? Standing on top of the bed, wearing a cape, then realizes it's Gannon, but she shoots him and stabs him and does all these other things to cover up for whatever. Does that make any sense? Or is this just another concoction, another way to point outwards on blame and show herself as the victim? When she realizes those external sources aren't working, Dr. Dorothy Lewis comes into play. Before she looks at a shred of evidence, in February of 2022, she's already said, yeah, you need to go with not guilty by reason of insanity. Dissociative identity disorder is the answer. Doesn't know a single thing about this case or this defendant in February of 2022. And so what does this defendant do but start creating names? There's Taylor, Harmony, Christina, Jasmine, the Frisky Princess, Little Lucia, and Maria Sanchez, Spanish-speaking Russian sniper. Knows how to kill, kill, kill. One thing we do know from this evidence, this defendant knows how to kill. Knows how to kill a defenseless little boy in his bed. There's better words to describe this defendant and what she did. Unreliable. Every person that she's ever interacted with in her life can tell you that she's unreliable, that she tells tall tales. She hated Gannon. You know that because of the injuries that Gannon suffered. You know that she hated Landon and Al. Why take away their little boy the way she did and concoct the story she did unless she hated them just as much as she hated Gannon? She planned this. A week before Gannon goes missing, she's already looking at renting a U-Haul and places to live in Florida. Sometime prior to Gannon's death, she searches, "I hate my stepson." Premeditated this thing. You know that from the proof of life photos. Those two pictures that she sends to Al on the morning of January 27th. She's setting up her excuse. Portraying Gannon as experimenting with drugs when she knows that she's drugging him with hydrocodone. She burned him Sunday night when this all starts. Gannon didn't play with fire. Not going to intentionally burn himself. In that first story about the candle incident, she talks about taking the kids outside and then having to go back downstairs to get Gannon. They all pile in the truck and drive off. That never happened. This was just a story that she had to explain away because the fire didn't work. Gannon didn't die from the fire. Then poisoned him with the hydrocodone. That didn't work. Remember, Gannon was a fighter. 1 pound, 6 ounce little boy when he was born. Overcame all the odds. But he couldn't overcome this one. But he sure did try, didn't he? She attacked him, stabbing him 18 times. Like I said, most of those are on his arms and hands because he's fighting back. Beat him over the head 4 times with some blunt object that's never found, cracking his skull like an eggshell. Shot him in the jaw, severing his spine, and likely killing him instantaneously. She then manipulated the heck out of this investigation with her stories. Her stories and manipulations of this investigation caused it to be the biggest investigation in El Paso County history. I heard that from several different investigators involved in this case. And it stretched from Colorado Springs all the way to Myrtle Beach, South Carolina. She hid Gannon's broken, dead body in a suitcase in that storage room. She ran from cops when the circle was tightening. Remember that trip to Marshall's? When the cops are going there to get cell phones and get the car that belonged to Harley? And they encounter her out in the parking lot. She takes off running. As soon as she sees those guys, she takes off running, throws the keys across the parking lot, starts yelling at Harley, "Don't say anything." Why? If she didn't know she had done something wrong, why? Then fled to Florida and then eventually South Carolina. Get as far away from this thing as she possibly could. That's why she's wanting to get a replacement passport so she can escape the country. She dumped Gannon's body over the bridge. Mr. Young talked about this. Think about how divine intervention plays a part here. Macon Ponder had been at that bridge a month and a half before then. Gannon's body doesn't get found for at least 2 years, if ever. She murdered Gannon. January 27, 2020. She murdered Gannon. This little boy deserves so much more out of this defendant. He deserved protection. He deserved to live. He deserved to grow up and become a young man and someday have a family of his own. She took it all away.
People that have practiced on a 911 that is the exact location of the emergency. Well, just like you said in Linden Drive, Colorado Springs. Please say that one more time, make sure I have this here correctly. 667 Linden Drive. Okay, the phone number you're calling from? 843-55-7460. Your name? Leticia. Please tell me, sir, what happened? I didn't know if I'm sure to call emergency or not emergency but my phone says you all at 6 o'clock and it's almost 7. And we went to like our friend's house and but he's gonna be at his friend's house and they said he wasn't there and the other one said he never came there. I don't know any other people calling out and I talked to my husband, so I told him I had to call you guys as fast as I could because I don't know anyone else. And I don't know if there's like a time limit, but like he's only 11. He's 11. 11, yeah. Okay. What's his name? Gannon. What for me? Okay. Last name? Stauch. Stauch. I can barely, guys. I got it hard. I can barely, guys. If I have the information in here, and I think you have multiple questions, we have to ask you, we don't want to tie up an emergency, if you're not emergency. Yeah, that's fine, that's how I didn't know which one of them. Yeah, that's okay. Let me know when you're ready for that number. Okay, go ahead. 719. Okay, can you put me on? 19 390 390 5555. Okay. You're welcome. Call that now. Call that now. I already have the call built. We have no things to ask. So, we'll call back tomorrow. Where we left off. I think maybe the process is speaking. How can I help you? Hi, yes. I called 911. And they said I had to call the stepmother because my 11-year-old son was supposed to come home at 8. But he didn't. I know it's only 7, but like we went to both his friend's house and they said he wasn't there. And it was kind of like a evening and stuff. I was like, what's your last name? Maybe around like what time did you guys go to bed? Is it 3:30 maybe? Between 3:30 and 4, and he was supposed to be at home at 6. We met him all the time, like go to the neighbor's house, friend's house, they ride bikes and everything together. And we're constantly to see him. I guess me.
Ladies and gentlemen, you're going to go back into that deliberation room and start deliberating. Gannon deserved justice. This defendant deserves to be convicted based on the evidence that was presented in this case. Gannon Jacob Stauch, 11 years old. Find the defendant guilty of murder in the first degree after deliberation. Murder in the first degree child under 12 in a position of trust, tampering with a deceased human body, tampering with physical evidence. Gannon deserves it. Deserves all of this justice that you can give him. Thank you.
Mr. Allen, can you get her those
Yes,
lists, please? Thank you. All right, lady. All right, ladies and gentlemen, as I indicated earlier when I read the instructions to you, there are 4 verdict forms, one for murder in the first degree after deliberation, one for murder in the first degree, child under in a position of trust, one for charge of tampering with a deceased human body, and one for tampering with physical evidence. In a moment, I'm going to send almost all of you back to the deliberation room. And members of the jury, I want to thank you for listening so closely to the evidence in this case. Because most or all of you have not served as jurors before, I would like to give you a few pointers regarding the process of deliberation. However, unlike the instructions that I gave you, these are only suggestions, and you are free to proceed in any way you wish. First, you may wish to choose your foreperson who will preside over your deliberations. You may already have a good idea of someone that you think would be fair, a good listener, and a good discussion manager. Pick someone who is willing and able to help the discussion remain organized and respectful. Remember, however, that the foreperson's opinion has no greater value than that of any other juror. Second, you should reach some agreements about how you will conduct yourselves. The foreperson shall enforce or encourage compliance with these agreements. If he or she is unable to do so or engages in this conduct him or herself, the jurors have the right to select a new presiding juror. Jurors are often tempted to hold a preliminary or straw vote at the beginning of deliberations in order to determine whether they already agree or how divided the group may be. I recommend against this procedure because it may cause some jurors to lock themselves into a position which they will then feel reluctant to change. Experience has also shown that such early votes frequently lead to disruptive, unnecessarily lengthy, and inefficient debate and to ineffective decision-making. If you reach a particularly controversial or difficult point in the discussion, you may want to move to a less controversial or simpler area for discussion and return later to the more difficult issue. You may wish to consider secret ballots if the jury would feel more comfortable with this procedure. You each have the right to your individual opinion, but you should be open to persuasion. It helps if you are open to the possibility that you might be wrong, or at least that you might change your mind about some issues after listening to other views. Misunderstanding can undermine your efforts. Seek clarification if you do not understand or if you think others are not talking about the same thing. The foreperson or some other juror, as agreed to by the jury, may wish to take notes of agreements and disagreements and, from time to time, set out the items on which you agree and those on which you have not yet reached agreement. You must deliberate as a group while you are all together. In spite of your best efforts, it is indeed possible that serious disagreements may arise. In that event, recognize and accept that getting stuck is often part of the decision-making process. It is easy to fall into the trap of believing that there is something wrong with someone who is not ready to move toward what may be an emerging decision. Such a belief, however, is not helpful. It can lead to a conflict of personalities rather than a conflict of issues. It is best to be patient with one another. Taking a break can often be helpful and lead to a satisfactory conclusion. The bailiff is available whenever you need to stretch, to calm down, to clear your minds, take a walk around the building, something of that nature. As I indicated, however, these are only suggestions, and you are free to proceed in any way you wish. When we began this process, I told you that we were going to be selecting 12 jurors plus 6 alternates. The reason why we do that is because in any case that lasts for longer than a day, if something were to happen to a juror during the process, I would have to declare a mistrial, start all over on another date at another time from the beginning with a whole new different crew. This was the first trial of any length that we've had since COVID. I have had long trials before, and I understand that things happen during trial. Sometimes people have family emergencies during trial. Sometimes people get sick. Sometimes, as in this case, we had a juror who didn't know that they knew a witness until that witness got here. So we always try to plan for that because we don't want to have to put everybody through another trial at a different time and start all over without any potential of resolution and without any potential of getting through all of the evidence. However, the law only permits 12 people to deliberate in this case. The alternates in this case are chosen at random. I'm still going to refer to you as number to protect your privacy. So we have 9 people in the back, number 10, number 11, number 12. You're 13, 14, 15, 16, 17. 13 through 17 will not be deliberating. I'm going to excuse jurors 1 through 12. And Mr. Combs will take you back to the deliberation room. And there should be, do we have food? No. There should be food, or food is on the way. We are working on that. So please be patient with us. But we're going to send 12 of you back now. The other 5, please remain in the courtroom because I have further instructions for you. I'll rise for the 12 jurors, please. Thank you. May all be seated. Records should reflect that the 12 jurors have left the courtroom. We get to this point in every case, almost any case that lasts longer than a day. And I always feel terrible for the people that are the alternates because you have put in just as much time, effort, and energy as everyone else. You have dedicated a lot of time to this case over the last 7 weeks, 8 weeks, wherever we are. But you don't get to deliberate yet, which is why it is possible, and we just had it happen last week in a different case, where one of the jurors had to be replaced by an alternate. So this is going to sound a little strange. I'm going to release you, but you're not excused from jury service. What that means is that you're not going to be deliberating back with the 12, but you still cannot discuss this case among yourselves, cannot discuss the case with anyone else, cannot do your own independent research about any aspect of the case. The reason for that is it is possible that I would still need your services if something were to happen to one of the jurors that is deliberating. What I'm going to do is I'm going to have Mr. Sproul take you back to an alternate jury room because you guys have 2 of them back there. But I want to have a conversation with you about some security things and some publicity things and also some services that we offer. So I want to have that conversation with you before we discuss anything further. And you're welcome to stay in that jury room for the rest of the day. You're down here. I don't know what you want to do. We can talk about that, but we'll talk about all that back there. I do have certificates of service for you. And I also have a questionnaire, which I'm going to ask you to fill out. It's something that the state of Colorado sends out to jurors. So if you would take the time to fill it out, and I'll be back to talk with you in about 10 minutes or so, I'd greatly appreciate it. All rise for the jurors, please.
I am literally dying over here, Deanna. Gosh. I understand what you're saying, though. Even funnier, I was just
Thank you.
thinking,
May all be seated. Record should reflect the jury
hold
has
that
left the
thought.
courtroom. I have a couple of things, some announcements, primarily an advisement, I suppose, more than anything else. First of all, I will need contact information, clean laptop, and for anyone who's listening or interested in the ultimate outcome of the process, the plan is that once I am advised that a verdict has been reached, I will be contacting Mr. McCallum and Mr. Sarche, who are the public sort of information officers for the Colorado Judicial Branch, and they will send out a tweet. I'm going to, I will not be taking a verdict until 30 minutes after it has been announced, or I'm sorry, until 30 minutes after I send that to Mr. McCallum and Mr. Sarche. So the plan is that everybody will have 30 minutes time to be able to get back in place, and then we'll take the verdict. I also want to thank the attorneys for their presentation in this case. More importantly, I want to thank the lawyers for the presentation or for the professionalism that they have demonstrated throughout this trial. This was a long trial. It involved difficult facts. I know it was hard on the jury. I know it was hard on the families. I know it was hard on the defendant. I also know it was hard on the lawyers. This case was logistically complex. There were lots of witnesses from lots of different places. All of that had to be coordinated to get them here. There was a lot of evidence. I think I've spoken with the court reporters. We're getting a little bit better at it, but it still takes us about 20 minutes to get all of the evidence from the courtroom into the evidence room at the end of the day. And the lawyers had to review all of that, both sides. They had to figure out how each piece of evidence related to a different piece of evidence and what witnesses related to what pieces of evidence. One side had to put all of that together and the other side had to figure out how to defend against it. That both sides had very difficult jobs, but with the exception of one or two exceptions, at least as far as I could see, you acted professionally with each other and respected that opposing counsel had a job to do. In a case that could have been made so much worse by bad lawyer behavior, all of you rose above that. I appreciate that. From a judge perspective, may not mean much, but from a judge perspective, I think you have put on a clinic for how cases should be tried. I've always thought professionalism among lawyers ultimately benefits the client, but I know that not everyone agrees with that. So, but I wanted to thank the lawyers for the presentation because I know how difficult this case was for everybody. So we need contact information for the lawyers. I've given an advisement as to how the verdict will be handled. And I suppose if there are any questions, we'll take up the issue of defendant's presence during those questions or whether she waives presence. Okay, we'll make sure that happens. Is there anything else that we need to address at this point in time, prosecution?
The only thing, Judge, this is potentially only anticipating issues is if the families can't get here within 30 minutes, we may be asking for you to push that a little bit longer. There's childcare issues and that kind of thing. And I know you'll be gracious with that.
I will, and I understand that. We'll take it up if it's an issue. All right. From the defense, anything that we need to address? Okay. All right. Thank you. Court will be in recess.
All rise.
All right. Sorry, guys. I had to go control the grandkids for a few minutes. They're out of school on Fridays. I don't know how to feel. I don't know if I'm surprised that this whole part is over now. I don't know if I feel nerves. I'm not sure. Butterflies. Yeah. But the reason real quick why I got such a giggle out of Deanna's comment was because I was just thinking to myself that Tiffany always posts the sweetest comments and stuff in chat, and the rest of us are like, let her burn in hell. You know what I mean? So I was just thinking, Tiffany, you're so sweet. And then Deanna commented what she did, and I just found it too funny. So we are on verdict watch. I can't believe it. It's been a long time coming. Real quick, let me go over what was last said, and kind of recap what the prosecution rebuttal was. But most importantly, and I was trying to say it when court came back in earlier, or when the attorney switched, that the defense was saying the burden of proof is not whether you decide you think she was psychotic at the time. It's, did the prosecution present enough evidence that you can say that there is no way psychosis was at play here. He said all the evidence points to mental health or mental illness, and the prosecution has not disproven that. So yeah, I've had bad butterflies, anxiety. This is definitely something so many of us have waited years for, to get justice for such an amazingly beautiful, sweet young boy who I feel deserved so much better from those around him. I really pray that his little sister is able to live a much better life despite all of this. So in the rebuttal, the prosecution said the only fantasy is that she was insane at the time. The judge never said anything about motive in jury instructions. Motive does not have to be proven. Yet prosecution says they proved it anyway. Said she hated Gannon. We know that because she searched it. She was planning to leave Al. She wanted to hurt him. She wanted to hurt Landon. And she did, to the core. He said they'll never recover from what she did to them. Think about the time frame we're talking about. This wasn't instantaneous. This occurred over days. She was planning a week prior to her killing him. He said, we know this because of her searches. Al would have left had he ever seen signs of psychosis, but he couldn't see her heart and the feeling that she wanted to hurt Gannon. He said the defense wants you to speculate that the fire set off a trigger, yet instructions to the jury say you cannot speculate. They want you to ignore evidence and speculate. Saying she's freaked out in that phone call, we all get freaked out sometimes, but her freaking out is an act. It's all about Leticia. The whole thing, it's about her. Her text to school that morning, they want you to speculate that it's some sort of a trigger. It's not, it's an excuse. A horrible one at that, to use a stepfather's death as an excuse. She knew what was going to happen later that day. That's also why she called him out of school. The timeline tells you everything you need to know about her calculating, manipulating, lying condition to reflect the blame and make herself the victim. It wasn't psychosis when she did this. He said, Mr. Tellini wanted to introduce speculation to you, but be careful about that. He also tries to brush off the effect of hydrocodone. And the state said Gannon shouldn't have had it in his system to begin with. It's an opioid, and he was only 11. So why did she do that? Because she wanted to kill him. Mr. Tellini brought up that the brutality proves psychosis. The evidence shows the defendant's own actions, her hatred for Gannon, and her pure determination to kill him. It didn't start in one snap moment. It started Monday night with that candle. She wanted to make it Gannon's fault. Gannon didn't play with fire. He didn't randomly light candles, but he had a long history of stomach issues. And this day he poops himself. So he has to burn a candle to mask the smell. And prosecution says, does that make sense? Or does it make more sense that she burned him? That's the start of the attack. Then continues with the hydrocodone. He walks slowly to the truck because he's under the influence of hydrocodone. She drives him around, and he's probably passed out in the car while she's driving him around. Yes, Donna, they, I guess you say went to lunch. They're having lunch delivered, but they are deliberating now. They brought Al of Gannon in bed. It was a way to cover her tracks early on. He then said, they want you to think this was a temporary snap. There's not a temporary insanity plea in this case. It goes on for almost 24 hours of suffering for Gannon, which should have been the safest place in the world for Gannon to be. And then he says everything in her life is manipulation to cause chaos and make her a victim. Harley didn't even know how her own father died. So why would she stop lying now? It's who she is. She's a storyteller. But telling fantastic stories is not psychosis. It's just who she is. He said she starts looking up face implant centers, social security number replacements, replacement passport, fake polygraph, etc. Why do you need a fake polygraph unless you're covering your tracks? He said their star witness didn't even know what insanity means under Colorado law. Anytime she was pressed for her opinion, she couldn't do it. But yet Dr. Torres could, and he asked the jury to compare the two doctors. He said, we have the burden of proof. She has the presumption of innocence. We expect and welcome you to hold us to our burden of proof. Then he went on to say Mr. Tellini talked about proving it without a doubt. And he said, you will never see words like that in any jury instructions in the United States. You prove things beyond a reasonable doubt, not 100% without a doubt. If a case is not proven beyond a reasonable doubt, then it's your job to find the defendant not guilty. If we've proved it, then the jury instructions tell you to find her guilty. They went on to say, can this defendant distinguish right from wrong? The evidence and her actions tell you that she can. If she had suffered from a condition that kept her from forming a culpable mental state, you don't stab an 11-year-old 18 times, as he's defending himself, unless you intend to kill him. You don't then dispose of an unrecovered knife and hit him over the head 4 times to the point it cracks the skull. That object was also never found. But that wasn't enough, so then she retrieved a 9mm handgun and squeezed the trigger 3 times intentionally, hitting Gannon 1 time. So that's what this defendant did. She doesn't have a diseased mind or psychosis. The defendant knew then and today, right from wrong. She was of sound mind. Except first she blamed Gannon. He pooped himself, started a fire, experimented with drugs, has a Swisher Sweet planted in his backpack, and hydrocodone in his system. What a convenient concoction. She then says he went to a friend's house and didn't come home. Was it because he loved his mom too much? He was a mama's boy. She knew she could never replace the love that Gannon had with Landon. So then she concocts Eduardo and gives Eduardo access to the garage. But in addition to fixing the carpet, he rapes her, then asks for boxes and a suitcase. She introduced the suitcase to explain why he would be found in the suitcase that she put him in. But next it's Quincy Brown's fault. Detective Grusing says he wishes that he would have pushed more about that and expanded on the Quincy Brown character, as she gave the most information about him. He was a real guy. He was on the most wanted people in El Paso County for sex offenses. So he was like the perfect fall guy. So she replaced Eduardo's name with his. Then it's the pregnant cash lady involved in money laundering. So she pointed in every direction except for her. But in every story, the blame is always on someone else, and she plays a victim in every single story she concocts. To explain her GPS up in the lake area, she comes up with that bike story and why Gannon's blood would be found there. And it's also Landon's fault. Somehow she's responsible because of her ex-husband that Gannon ended up in Mexico. But why was Mexico introduced? Because by the time she said this, he had been pitched over into the Escambia River that flows out into the Gulf of Mexico. That's why I always say there is always a little bit of truth in every lie. Also, Al's fault because he was gone and he contaminated the crime scene, etc. So she went after the people who loved Gannon the most, showing the hatred she had for those people and for Gannon. Her stepfather, James, who supposedly essayed her as a kid, it's also his fault that she's the way she is. But there's no evidence she ever suffered any ill harm by James. And I think that's something that we should be careful with. She never reported it to a single person for over 20 years, yet that's the trigger. Does that make sense? And then the caped invader. She didn't realize he was Gannon, yet she shoots and stabs him. Another way to point outwards on blame and show herself as the victim. Then when those external sources didn't work, Dr. Lewis comes into play, and before looking at a shred of evidence, Dr. Lewis tells her to go with not guilty by reason of insanity and dissociation identity disorder without knowing anything about the defendant or the case. So then Leticia starts making up names. He said because of his injuries, we know she hated Gannon. She also hated Alan Landon. Otherwise, she wouldn't have concocted the stories. She planned this a week before Gannon went missing. The proof of life photos shows she premeditated it. She was setting up her excuse. She burned him Sunday night when this all starts. But Gannon didn't play with fire, and he's not going to intentionally burn himself. In her first story, she talks about taking the kids outside and driving off in her truck, but that never happened. It was just a story. She never did do that. And I'm not sure if we saw that evidence, but the state is saying that never did happen. The fire didn't work. Hydrocodone didn't work. Neither did the stabbing. So then there's the 3 gunshots. So that's where we're at. Now we are on verdict watch. The judge said there will be a 30-minute notice before the verdict is read, and we will find out by Twitter. Kind of funny. So I'll be watching for this without a doubt. And as soon as I see that pop up, I will make a live. If one of you see it, please don't assume that I have. And please message me either on Discord or on Twitter immediately. And the Discord link is still in there. But if not, let me put it in here again real quick. The Discord's free to join. We're just getting it started. So, but yeah, you can Discord me on there. That too. So yes, what a roller coaster ride. You guys are always awesome. So I'm going to end this live and then we are going to wait. I think there will be a verdict today. Actually, I think I'm almost certain there will be. I think it'll be a very fast one. So be on your toes, gals. And we'll meet back up as soon as we have that. All right. Thank you so much. You guys enjoy the day, what you have of it. And hopefully we have news really soon. Thanks, you guys. Bye-bye.